All right, so, excuse me. I'd like to welcome everybody who is here and everybody who may be watching to a meeting of the Licensing Committee of the Board of Psychology, October 13th, 2017, Sacramento, California. We're going to call roll to see who's here. So,
Fu? Here. Horn?
Here.
Phillips?
Here.
Okay, thank you. All right. Before we move to the approval of minutes, I'd like to ask if there is any public comment for items that aren't on today's agenda. And just to let you know that we can't discuss or take action on any comments at this point in time, but we can consider them for a future agenda. Any public comment? All right, seeing none, we will move to approval of the Licensing Committee minutes from March 16th and 17th, 2017. Yes.
Just so people don't get confused, if people are watching or listening to the broadcast or walk in, the reason we're looking at computers is not because we're surfing the net. It's because we've gone paperless. So we're using these laptops for business purposes. Thanks.
Thank you. That was a good thing. So we're going to have to get used to this. We haven't ever done this before. This is the first meeting we've used. Everything is green. So, all right, so we're looking at the minutes from Thursday, March 16th, and Friday, March 17th, is that right? I'm just looking forward ahead. But anyway, so I want to ask now, are there any additions or corrections to the minutes?
I had none.
You have none? Okay, well, I have a few. So on line 55, on May 16th, it just says approve the minutes as amended, but I don't see anywhere anything was amended. It's not clear to me what was amended. I know it looks like we discussed this issue, but it doesn't look like we changed anything in the minutes. So.
That's my recollection as well.
I'm sorry?
That's my recollection as well.
Okay. So if we would just say moved and seconded to approve the minutes, period. Line 59. This wasn't quite understandable. I don't think it said exactly what we intended to, what actually happened, so I've changed it. I want to ask if y'all think this is okay. Because Ms. Jones would not be present on March 17th, Dr. Horn said the committee would move agenda item number 4 to the following day in order to allow Ms. Jones to participate in the discussion on agenda items 5A and 5B items. 5A and 5B, pathways to licensure. Dr. Horn added that the committee would also meet in closed session today to allow Ms. Jones to participate. Okay, I can give that to you. I'll can send it to you later if y'all are okay with that. All right. Line 72.
Can I go back very quickly? My notes do indicate a very, very minor change from those minutes.
Okay.
Very small. There may have been others, but the one I think I noted was a small grammatical change. And my notes do say that the motion was to approve as amended.
So we should say that, I think, in our minutes, that there were some minor changes to the minutes. and then they were approved as amended. Otherwise, it doesn't look like. Okay? So is that all right, we'll do it that way? Thanks, Ms. Marks. Okay, line 72. Began this, well, this is just little grammar stuff, so I'll just give that to you. Lines 84 and 85, well, 83 to 85. According to section 2909, those positions are exempt because these individuals are working in organizations and that their primary function is not to provide mental health services. But I thought the reason those positions were exempt is because the people can be called psychologists, but only within that setting. Not because they're not necessary, because they may be providing mental health services. So, y'all agree with that? Is that correct? Does that make sense?
I guess I'm a little confused. It does make sense that they call themselves psychologists within the context of
Because
your
these are exempt positions. The positions are exempt because they're in specific settings where they can be called psychologists. They may be performing psychological duties, but outside of that setting, they can't perform those duties and can't be called psychologists, is my understanding of how this goes.
On 2909B, it says that if those persons are employed in positions as psychologists or psychological assistants by approved colleges, junior colleges, universities, or federal, state, county, or municipal governmental organizations that are not primarily involved in the provision of direct health or mental health services, that they may conduct research and disseminate their findings.
That was my understanding, that these are people that are not involved in the direct delivery services. The psychologists would typically do.
But what about people who are called psychologists, say at a college counseling center? They're called psychologists, but they don't have
And they can.
and they are performing mental health services.
And they can do that for 5 years under the supervision,
Right.
gaining hours towards licensure. So that's kind of the difference between the two.
Between the difference between exempt
2909
settings and
and
exempt
permitted.
status?
Yeah.
Okay. So this is the same thing that hung us up at the stakeholders meetings too. So it reads correctly then? Lines 84 and 85. Sorry, everybody.
No, I think that accurately reflects the conversation, as I recall it.
Okay.
Can I suggest an amendment to line 84, 85? That these individuals are working in certain organizations,
Good.
or certain types of organizations?
Yeah. Yeah, because the organizations are the exempt settings, so, or working in certain types of settings. And that they're primary, yeah, that would be good.
Great.
Certain types of settings.
Yeah.
Certain types of settings or
Setting.
organizations?
I'd say settings.
Settings, okay.
Yeah. All right. Let me see. Then I just made some changes to how we wrote the B&P codes and the changes that we made. But I'm just going to give that to y'all because we're going to go over that later. 2913, services by psychological assistants, that's going to be part of our pathways to licensure and stuff, right? I'm sorry, lines 190 to 194. Or 180, starts with 186. Services by psychological assistants. I'm sorry?
So that was just a summary of the discussion regarding that
Okay,
section.
then again, it read a little unclear to me. It's not that they can't guarantee adequate, psychiatrists can't guarantee adequate socialization because they didn't we can't require them to take the course in supervision. We can't guarantee there's adequate socialization into the profession, and the board cannot require a board's, there are two things. Because they're psychiatrists, we can't guarantee they adequately socialize people to be psychologists. That's number one.
What lines are you looking at, Dr.?
Okay, so here's how I changed it. It starts line 186, that section. So what I said is the board does not have any control or oversight over psychiatrists. This is line 189. And part of supervision is to provide adequate socialization. Part of supervision is to do that in preparation for the trainee.
If it's different on yours.
The board cannot guarantee there is adequate socialization into the profession for the trainee, and the board cannot require a board-certified psychiatrist to take a course on supervision that is required of all psychologist supervisors.
That sounds good.
Those people who are accessing the webcast, if we could refer to the hard copies, because that's probably what they're accessing.
Right.
I'll
So
just
read
also
the-
let you know.
Okay.
So where you started was 178 on the hard copy.
Oh, okay. Sorry.
That's okay.
I don't know why it's,
Because you made changes, so the.
oh, okay. All right, thank you. All right, so then I'm talking about the paragraph, I've got line 207 here. It said, staff was tasked to find out how many psychological assistants are currently being supervised by board certified, it should say psychiatrists. Okay, then line, what would it be? I've got 214. Dr. Phillips stated. 203. Dr. Phillips stated that psychological assistants he has talked with feel hampered. Blah, 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 blah. And the last sentence in there, it seems that other providers can advertise as long as the public is made aware. Then I had a question, Ms. Marks, and I'm not sure. Line 215, where you say it raises questions, I put about the appropriateness for a psychological assistant to advertise on behalf of the supervisor.
Yeah, I'm not sure I quite put it in those terms. I think it was I think what I was questioning or saying that questions are raised if the clients are the clients of the supervisor, does it create some questions if the psychological assistant is advertising and yet advertising to bring in clients that ultimately are the supervisors? I think that was the question that I was raising. It's not quite so much advertising on behalf of the supervisor, but advertising to attract clients, but the clients are really the clients of the supervisors. That was a question I was raising.
Right. Well, I wonder if there's another way we can state it. Dr. Phillips, you're good at this, because this isn't exactly what you meant, right?
No, it's not quite right, because it's not on behalf, it's not.
Right.
This, I think I will go out and advertise for my supervisor. It's advertising to obtain clients that in the end are ultimately the supervisor's clients.
That would be a better way to say it. Thank you.
Do you need clarification?
No, I don't.
Okay.
Thank you. I keep looking at Mr. Glassbeagle, but are you taking notes? Did you wonder why I kept looking at you? Sorry.
Following along.
Okay. All right. I'm sorry, these are so long and I'm going through. I don't want to waste time.
Dr. Horner, I know you mentioned there were some changes in the actual language
Yeah.
itself.
Yeah.
If you want to just keep that document up for purposes when we get to the pathways discussion, just so we don't lose
Yeah, sure.
your changes.
Sure, I'll do that for sure. I'm just about, yay!
That's it.
Those are my questions and amendments.
Move to adopt. As amended.
As amended. which
As
you
amended.
Second.
Okay. So we need a vote on that, Mr. Glassbeagle.
Public comment.
I'm sorry?
Public comment?
Oh, thank you. I'm sorry, y'all. Is there any public comment on these minutes from March 16th and 17th, 2017? Seeing none.
Who? Who? Aye. Horn?
Aye.
Phillips?
Aye.
Yes.
Okay. Now, let's see. It is time for the minutes from the, which one? May 4th meeting. That's May 4th meeting notes. The minutes, we don't do the meeting notes, we do the minutes from the May 4th meeting, right?
Those are the
Right.
minutes.
Okay. The minutes are the solid notes?
Yeah.
Okay, all right. So let me ask, are there any corrections or additions to the minutes from the May 4th, 2017 licensing committee stakeholders meeting?
I'm a tad confused about how we handle this procedurally. The solid minutes are the solid minutes.
Right.
They wrote down whatever they wrote down.
Exactly.
So I think the only thing that's within our ambit to comment on would be the first page.
That's what I would think. Yeah, I agree with you.
And I have no comments on the first page.
All right. So is there any public comment on those minutes from May 4th, 2017? They have an attachment to them, and those are the solid notes, but those are the solid notes, not notes we took. All right, seeing none, Mr. Gillespie.
Fu? Aye. Horn?
Aye. We don't have a
We don't have a
motion.
motion.
I'm sorry.
I move that we approve those minutes.
And I second.
All right, now Mr. Gillespie.
Fu? Aye. Horn?
Aye.
Phillips?
Aye.
Yes.
All right, our next meeting, minutes are the August 22nd stakeholder meeting minutes. And it's, again, a one-page document with some solid notes attached to it. But this is the one-page document about the minutes. Any corrections or additions to that?
I
Any
move we
public-
approve the minutes.
And I second.
Okay. Any public comment about, excuse me, those minutes? All right, seeing none, Mr. Gillespie?
Fu? Aye. Horn?
Aye.
Phillips?
Aye.
Pass.
Okay. Yeah, thank you. All right, we're going to skip ahead for the moment to take this agenda out of order because Ms. Snyder can only be here for a little while this morning. So we're going to move to item number 7 on the agenda, examination subject matter experts. Qualifications. Ms. Snyder?
Did it work?
Yeah. Just wait until.
Did I not?
Just want to make sure. Yeah. let's
Yeah?
do that.
Okay.
It's working.
So for those of you who are watching, we are trying to get our technology set up here so that we can actually see what Ms. Snyder's about to present. And all of you can too.
Can I drive it? Do you mind?
Yeah, so if you can't carry it all the way over there. But, yeah, try it. See how long. Yeah.
Good morning. My name is Lavinia Snyder. I am the examination coordinator for the Board of Psychology. I am here today to provide the committee just a brief overview of the examination development process for the California Psychology Laws and Ethics examination. The CPLE, or the CPLEE, is developed and maintained by the Office of Professional Examination Services, a division of the Department of Consumer Affairs. They provide psychometric consulting services to the board regarding our occupational licensure examination. All our workshops are facilitated and conducted by OPES at a secure facility in Sacramento. The purpose of the licensing examination is to protect consumers by verifying that new licensees possess the minimal knowledge and experience to practice in California. In order to develop such exams, the board recruits licensees as subject matter experts during a 2-day annual workshop and to assist to develop those examinations for us. We have 4 types of workshops. The first one is the item writing workshops. SMEs in this workshop, they develop new items for our exam. The item review workshop, there are 2 parts to this workshop. One, the SMEs get to review the newly developed items for our workshops. And then the second part of that is they get to review the previously used items based on item statistics and candidates. So they review those items. Let's say they find out that a question may have been relevant 5 years ago and may not be relevant today. So they have a chance to review those as well. The exam construction workshop, the purpose of this workshop is to select potential items based on the examination plan of the CPLEE. Participation will evaluate items for each content area included in the examination and select those that best represent the knowledge required for entry into the profession. Last one is the passing score workshop. In this workshop, participants get to, once a version is completed, they get to determine what the passing score is. The passing score is based on a criterion reference methodology called the modified Anguff technique. And the way that was explained to me is that if the passing score is based on the difficulty of the exam. Subject matter expert qualifications. In order to participate at our workshops, you have to hold a current, active, valid license, in good standing, having no prior or pending disciplinary actions or pending investigation or enforcement actions, and you can't participate in any exam coaching or preparation activities. So if you are a professor at a university providing laws and ethics, you wouldn't qualify to participate at our workshops. Selection process. First, we randomly select 500 licensees, old and new, who are in good standing from our licensed population. Aside from that list, the board has an interested parties list that we use, and this list contains licensees who have expressed interest in participating at future workshops. In this random selection, this is where we gather all active licensees who are in good standing with the board. From that list, we extract all the email addresses, and we send a mass email invitation out to everyone. And this invitation will contain workshop dates, workshop descriptions, and travel arrangement information. There are at least 8 workshops offered each year. Workshops require participation from at least 10 to 12 licensed SMEs. OPS only needs 8 to 10, but because of the number of cancellations I've received in the past, I try to overbook those workshops. Workshop responses are reviewed and assigned to their requested date and all alternative dates. It's on a first-come, first-served basis, so the sooner they get that information in, the sooner I can get those dates for them. A second enforcement review is conducted for each participant from the time we pull the extract and from the time we receive responses. A lot of things can change during that time, so we try to do a second enforcement review. Confirmation of participation in the workshops are emailed to licensees. Licensees must complete and return all state contract forms prior to the date of the workshop, otherwise they can't participate at our workshops if we don't establish those contracts. Reminder emails are sent to each group a month before, and travel arrangements are made a month before. What are the benefits? Each SME that participates will receive 16 hours of continuing education credits. That's live, those are live hours of continuing education credits. Satisfy the laws and ethics requirement. Get a $600 honorarium fee for participating at the 2-day workshop, and participants will also receive reimbursement for travel expenses with, of course, set limitations. Last but not the least is the schedule for this fiscal year. And the next scheduled workshop is the CPLE item review, which is in November. So that's it. Do you guys have any questions?
Yeah, I have a question, and I guess it goes to the question of subject matter experts.
Mm-hmm.
So we're pulling just from the general license population that has a clear record.
Right.
So they come together and they construct questions about, for instance, and it's primarily focused on law and ethics, if I understand correctly.
That's correct. It's focused on the examination plan, and each examination plan has a specific content area based on the occupational analysis.
Okay. I guess the question I have in my mind is, we don't use experts in law and ethics. For instance, we wouldn't use professors that teach classes, which I understand,
Okay.
because you don't want them preparing their students for the examination based on their knowledge of the
Yes.
examination. But I'm wondering how do I put this? I have great faith in our licensees, but I wonder to what extent we do a secondary check to make sure that the items as they're constructing them are actually an accurate representation of law and ethics.
And that's why we have these different workshops, because the first one is the item writing, which they create the newly developed items. And then we have a second group that reviews that for relevance, clarity, and accuracy. So we have different groups.
Can I also say there probably, just from what I know about exam construction, say at the EPPP, within each broad area, there are certain categories that the job task analysis identifies.
Mm-hmm.
From, psychologists in California, what do you do, and all this kind of stuff. And so the questions will be written to those more specific areas, so that all the areas should be covered that psychologists are doing in California.
Yeah, I guess my concern is that there is, I think there are some common misconceptions about law and ethics among psychologists in California. And if you got the wrong group of people to do both the development and then the check on accuracy, that they may actually be asking a question with an answer that's not a correct statement of either the law or the ethics code. For instance, I'll give an example of that. For instance, a lot of psychologists in California seem to think it's okay to do couples therapy with people they're also doing individual therapy with. That is clearly, based on the literature in law and ethics, not permissible or advisable. So I'm not sure how we catch that slippage that may occur between what's considered common knowledge as to law and ethics and what is actually an accurate representation of the legal and ethical standards. Does that make sense?
Yes, but
I can
Yeah.
answer it. Can you answer it?
no.
Because every item has to have a reference, And so there will be something in the ethics code. So that slippage should not happen because they're looking at the code of ethics or the law. Every single question that's written is a reference. So that if we take it and we don't do well, or somebody doesn't do well, then they say, well, they can be shown.
Would it help if I provide you with the different content areas?
That would be interesting to me.
Okay, I can email those content areas to you.
That would be great.
Okay. For the Feb, I can include that in the presentation,
And is that
yes.
something that our potential license candidates for license?
Yes, it's
should be
part of the
updated?
candidate information
Yeah.
bulletin,
Right.
so,
I think
all right,
that's
okay.
very-
And for clarification, the 10 to 12 selected is per workshop, is that correct?
Yes, that is correct.
So there's a total of about 40 to 46 selected for all four at a given time?
Yeah, yes,
And of the 40-ish
Yes.
selected from that pool, how many of them actually are randomly selected from that 500 versus the interested parties list on average?
well, for this year, majority of the information I received were from the interested parties list. So, and then this year, I'm going to run that report again and see the number of attendees that I get from that. And this next year, we will be conducting our occupational analysis, and so our workshops will include that occupational analysis. So at that point, I really don't know what the outcome would be.
And the goal of the 500 randomly selected is so that we are drawing from a broader pool of expertise and experiences.
That's correct.
And the ultimate outcome of these 40 persons selected seems to be more reflective of the interested parties list. And I would be curious to know if those selected reflect the randomly selected pool or the diversity of those experiences and subject matter at the outcomes of the 40. So if we can have that additional
Information.
when you do the occupational analysis, that might be helpful.
Sure.
Yeah, I guess my concern was that the people that would put themselves on an interest, and we don't want to discourage people from participating in
Yes.
board activities, so that's not my intent.
Well, I've done the randomly selected list in the past. I do that all the time. But I don't get a whole lot of responses from them, and that's why we created this interested parties list, and we put it on our website and posted it on our website if you're interested. And majority of the responses I get are from this group of people, even though I do send out that email blast to everyone, so.
What are some of the
The research does say that people who volunteer are different from people who don't. So it is a different group of people. I mean, that's what, but, you know, I don't know.
I mean, there's a practical question there, which is how do you get enough people to participate in these workshops? So, and I'm sure people have great motivations for putting themselves on the interested parties list. I can also imagine some smaller proportion of people having perhaps different motivations for being on the interested parties list, which is somewhat of concern to me.
Okay.
But we also, as a practical matter, have to have enough experts to look at the questions and determine what's appropriate for purposes of the test.
The one really good thing about this, every question is pre-tested before it's actually put on the exam. So if it doesn't have good statistics,
That's
it's
correct.
not going on the exam. I mean, it may be rewritten.
We do
And
have
try
pre-test
to-
questions that we include on the exam. So if those pre-test questions don't do well, then they go back to the workshops and have the SMEs review them again.
So there are items on the complete when someone takes it that are actually just there for purposes of checking the
Yes,
statistics as opposed to
right,
determining whether someone's passing.
That's correct. We have 100 items on the test, 75 items are scored, and 25 are pre-test questions.
And the potential obstacle for the randomly selected folks would be because the time off from their practice. Is that
Yes.
most logical?
Yes.
Great.
It may not be something that's of particular interest to them in terms of people have a lot of different interests in psychology, and test instructor may not be one of them. I wonder, do you think it would make an impact if you were to increase the number, and I'm just throwing this out
Increase the number of,
randomly selected?
yes, that's not a problem. That, it really isn't. I can increase that list.
I mean, my preference would be more people that are randomly selected than people that are coming off the interested parties list.
Yes.
Even though I very much appreciate the interested parties are interested.
So I have a question also. The items that people, and this may be for the Office of Examination Services, I'm not sure, but the items are created and read for clarity, relevance to psychology, I'm sure, or to the area, and technical accuracy. But what about important for public protection? Because there are a lot of questions that might be really good questions, they may be psychological questions, and they may be technically accurate, but they may not be, if we're thinking about what our goal is, and that is for public protection, is this, if you know this or not, would this make a difference in being able to adequately protect the public? Does that make sense? I'm wondering if, and again, this may be a question for OPES, or is that the right initials?
Yes, yes.
Thank you. I wonder if that's something to talk to them about, or something that we could say we want to include, that this is something that item writers think about as well. Is this knowledge that you really should have?
I really like that suggestion. I do think that most legal and ethical prescriptions as they relate to psychologists are for the benefit of the ultimate consumer. So but I think it would, if OPS feels that it would maintain the integrity of the test, I think it would be nice to have it as an additional criteria.
Would having an OPES, or I guess inviting OPES for the next workshop be helpful? For the next board meeting.
Well, perhaps the next committee meeting.
Yeah, maybe before we bring it to the board. Well, I don't know. Maybe bring it to the board.
Yeah.
Okay.
In January, then will be the next licensing committee meeting. We can have OPS come to that meeting. I know Ms. Snyder is going to be presenting at the February meeting for the whole board this similar information. And if there's any additional information you would like presented to the board in February, we can try and prepare for that as well.
That's perfect. Yeah.
Okay.
Thanks.
Is it possible to get a sense of what some of the past questions have been asked, or is that held lock and key and we can't? Okay. So no sampling.
Yes.
to figure
Well,
out.
we do have a sample included in the candidate information bulletin for our candidates, so that they have an idea of what to expect on the exam. But actual past test questions is can't.
Understood. Thank you.
Okay. Any more questions? Okay.
Ms. Snyder. That was very helpful. So we'll bring that issue and ask OPS to come to our January licensing committee meeting to talk about the kinds of questions or anything else that we have to talk about. And then at the February meeting, it'll all be combined. Okay, great, thanks.
Would it also help to have a copy of the SME application so you can see what information we're gathering?
That would be, thank you.
And if also possible, just to have a copy of the candidate,
The candidate information
the
bulletin, you
candidate
want that
information
included?
bulletin as well, so that you get a sense of what they're looking at.
All right. Thanks. Now, let's move on to, now we're going to back up. Oh, I also need to say that we're going to end today's meeting at 3:30 to go into closed session. And so I just want to say that. So now let's go back to item number 4, retired psychologist license. And who's presenting this, Ms. Chung? Are you presenting it?
Yes,
Were you
I'm
planning
presenting
on
on
it?
this.
Memo.
Do I need to?
It's all right, I can do this.
Okay.
So for this item, this is staff drafted language to implement part of our sunset that has created the authority for a retired status license for our existing current licensed psychologist. So staff is asking the committee to review the language and see what needs to be amended or any of the input for our consideration or to redraft any language if necessary.
Thank you. So this, basically, just to clarify, this was, we are, this section was added to the Business and Professions Code, which allows us to establish a retired category for licensees. And so that's what this is about. We're writing, this is the language that would enact that or allow us to enact that. So let me ask, are there any comments, questions?
You actually did it, Ms. Chung, when you were discussing it. You said you called it a retired status license. This says retired license, which I don't know, maybe it's just me. Looks odd to my eye.
You want to say retired status? That's fine. You can call it what, you know. What.
As long as that's not in any way contrary to the enacting statute. It'd be preferable to me. I think it would read better.
Are we okay to do that?
It does, it says in 2988.5, the board may issue a retired license to a psychologist who holds a current license. I do tend to agree with Dr. Phillips that it is probably more accurate to say it's a license in retired status, particularly because at least within the first 3 years it can be restored, that the active license can be restored. So I think and we do tend to think about the status of the license. It does strike me as odd to issue a license that doesn't allow you to do anything.
Right.
So I think you're probably right.
So is it all right if we make a change?
I was just pointing out 2988 for inactive status is inactive licenses. And I think that's why we chose to do retired license.
Is the board actually going to issue a new license that says retired? Are you issuing a separate license?
It would have a separate number, correct? Or no, it would just be a change in the status. Okay.
I just have visions of like my little paper license finally retiring, heading off to Europe.
So the changes there that Mr. Glass-Steagall, license in retired status. And then throughout it, if the retired status or whatever, throughout. I think this is really good. I mean, I'm really glad we have it, and this is for people who've basically just get to a point in their career where they're ready to retire. They're not, by and large, they don't plan on renewing it. They don't plan to work anymore. They are retiring their license. They are no longer going to work as a psychologist. They don't have any disciplinary action or anything like that pending.
And licensees have let us know that it's very painful for them to surrender their license.
Right.
When in all actuality, their license has been free of any kind of disciplinary charges, and they've just come to the end of their career, but they still think of themselves as a psychologist.
And it's an alternative to simply not paying and then let it go into expired status and then canceling. So it's an alternative to that. It's
Essentially never having to not be a licensed psychologist. You're just now a retired licensed psychologist. So, I'm really glad we,
once a psychologist, always a
always.
psychologist.
So with the understanding that this is just the beginning of the process, I'm curious to know which committee would then have the responsibility of thinking about how to convey this new status to the public, so that when they're searching on Breeze perhaps and they see retired status, that they may not be confused by what that actually means, or because it does change, I think, the way a person may be viewing what this actually means. So I would be curious, this is a question to the committee, is which committee would have that responsibility to work on or thinking about the messaging, or is that just a staff responsibility?
Typically, if there's a legislative change or a regulatory change, we will put out an advisory that is put on social media, sent to all of our interested parties list, all of our licensees, so that they know what does the change do and how does it impact them. So that would be something that we would do outreach and education on after, once it went through. Uh-huh.
I hear an article in there.
And you're going to write it.
He brought it up.
I am wondering though, and I'm looking at Ms. Lim, because I'm wondering for Breeze purposes, if there is a way that we can have a hover bubble over if you saw that was a license status of an individual and it said retired, if it had some kind of explanation on what that means. Because the main thing is we want a consumer to know that this means the person can't practice.
Yeah, so especially with the new license lookup, that there is that feature.
So, what do we do here? Do we,
Move to adopt. Oh,
I'm sorry.
I just have a couple issues on the language I want to throw out. In sub A, do we want to incorporate the form by reference? Okay, so we might want to include that. B, do we need sub B? It's pretty much completely duplicative of the statute. Do we need that? I understand that we want to make sure people know, but that we would just have to explain why it's.
What, if we took out is not subject to renewal, if we just said psychologist holding a retired status license shall not engage in the practice of psychology in this state.
That's also part of the statute. So there are times in which OAL will allow you to duplicate the statute in minor ways. I just want to throw it out there that OAL may say this. It's just both of those. The portions of that of B are in statute, so we may want to consider taking that out or trying to explain why the OAL is in there.
Like we want to highlight it or something. I mean, that would be our explanation.
The
We just want to
explanation
make
would be
sure
to have-
that it was clear to.
Right, it's, so that all the information is in one place. It's just that the qualifications, what allows you to even apply are in statute, so we'd have to explain why is this particular portion of that repeated. And then on C2, the fingerprints, do we potentially want to put in the language there about an electronic submission of the fingerprints? Because 144 simply requires the collection or allows for the collection of fingerprints. But I think do we want to start getting a little bit more specific about it being an electronic? And we can look at the language from 1381.7B on renewals that has that language in there. And then on sub E, the last one, I might just consider changing the language to a licensee may not be permitted to change his or her license to a retired status more than twice.
That's good.
And I really apologize, staff gave me the language in advance, and I just haven't had a chance to get to it, so I didn't have a chance to provide a written copy for the committee members, and I apologize.
Does E look
That's
for-
much clearer, I think.
Mhm.
I had highlighted that, but I wasn't sure.
Is that right, Norm?
Yeah, I'm not a big fan of using their, which is plural, when it refers to a licensee. I know some people don't like his or her, but I I prefer the grammatical
But if you say
correctness.
to change the license to a retired status, then,
Or a license.
or a license,
Well, it is possessive, it is his or her license.
I would say his or her. I have that same, as you know, that's no problem.
Nor is sub A, correct? Is that all you have?
Yeah, that's what, yes, I think that's all I had. Is incorporating the form by reference, so that incorporates whatever the standards are that are in the form itself. And I haven't seen the form, so, I'm sorry.
Would that need to be under C1 as well?
Is that a new form?
Yeah, that's,
Then yes.
no, is that the normal renewal form? It's a different, separate form?
Sorry, which form you're referring to? The 900 that we talked about?
905,
I think,
is that a new form as well?
yes, it's a new form, yes.
And after the closed parens on both of the words, there should be a comma before the word which on A and 1.
For E that we just talked about, is there a way to express that language in a way that is possessive but gender neutral? I know we're going back and forth on it, but is there a possible grammatical way to?
Is?
The license?
That works.
Back up a space. Yeah. Okay, is there any more comment on this section? Oh, we have to, I guess, move to adopt this, or do we have public comment? No, we move it first and then we have public comment.
So I move to approve the attached language as amended and incorporating the comments that Ms. Marks made, and to recommend to the board to adopt the language as amended and proceed with the rulemaking file.
Well, that, it's a recommendation for the board, right? The recommendation to the board to approve the language for noticing.
Yeah.
Second.
Okay, it's been moved and seconded to approve the attached language as amended and recommend the board adopt the language and proceed with the rulemaking file. Mr. Glass-Steagall? Do we have public comment before we vote? Oh, all right, thank you. Is there any public comment about this retired status license? The language as amended? Seeing none? Now, Mr. Glass-Steagall, I'm sorry. I'll
Who?
get it right before the
Aye.
end of the day.
Horn.
Aye.
Phillips.
Aye.
Passes.
It's too confusing to look at computer stuff and whatever excuses I have. All right. Now, let's see, I think we had, now is item 5, so I'm taking a look, it's 10 o'clock. Does anybody need to take a break or anything like that at this point, a few minutes break, or keep going? Okay. Keep going. I'm counting on you to let me know if you need to take a break. So item number 5, inactive status for a psychological assistant. Discuss the draft proposal. So,
Well, there was one broader question, I think, that was raised by staff, which is probably worthy of us discussing, because I don't think it's actually addressed in the regulation.
mhm.
And that is the question of how long can someone remain on an inactive status, which is of concern to me. I mean, I wouldn't want somebody to be able to have a psychological assistant registration and then go 10 years on inactive status and then still be within the time limit. So, because at that point, you'd start to question whether somebody had retained the knowledge in terms of the application of psychology. So I think we should give
still?
serious consideration to a limitation. I don't know if we want to make it a cumulative total. That the cumulative total be no more than 4 or 5 years on an active status, because they can take multiple inactive
Right.
statuses.
But it also might depend upon when they were in inactive status. If they were in inactive status early on in their registration, does that mean that when they have been active and practicing much closer to the time of applying for licensure, which to me would indicate that there's a greater safety there? That'd be the other side of that.
I think we have to think how to do this, because I agree with you. You know, if somebody has started and stopped, started and stopped, started and stopped, so has had a lot of inactive time since being trained, that I would have definitely have concerns. But I agree with Ms. Marks. If that inactive status was earlier in the training, maybe they had to take a big break to do some stuff and then finish their training and then, you know,
As opposed to
renew their psych assistant.
5 years off and then do the last 100 hours, that type of thing.
Right.
I wonder if we wouldn't address the problem sufficiently if we limited them to 3 years of inactive status total cumulatively.
How many years?
3 years. That strikes me as giving people sufficient time if they need to take care of things, if they're going to have a child, or there's illness in their family, on the one hand. On the other hand, to make sure that they're not so far removed from their graduate training that it's going to be problematic from the point of view of the consumer.
Can I ask a question of staff, and that is approximately how many requests does the board get for extension of the 72-month period?
Recently, we have received at least a dozen to about 18, like 12 to 18 is the number that I could recollect for a recent extension request.
And when you say recently, what is it?
Recently is from, I would say, from May to up till now.
Is part of that a function of the fact that the 72 months has now begun to impact people?
Mm-hmm, correct.
So,
Yeah.
and this is, this is really for the policy for the committee and ultimately the board to decide, but I think my questions would go to whether or not that would start becoming less as people are more used to the idea that they have to complete their SPE within a particular time period. And then the other question would be, how many of those 12 to 18 that the board has gotten, have they been requested the staff can grant versus ones that are not within the purview of staff granting and come to the committee?
We have about 4 cases that needs a committee review because they're more than 1 year. And then we have several others that fall out of the guideline rubric that provided by us that we need more clarification on. So I see that number is increasing versus then becoming steady or decrease anytime soon.
Yeah, I'm just not sure whether or not this is a solution for a problem that we're not quite sure we have. I would just be a little bit concerned about some of the impact that I've seen, that I can see here on 2 PSBs who are in the same situation. One goes inactive, one doesn't, and how does that potentially impact their ability to use their hours. And then I would have, well, if we were getting into more of the specifics of the language, then I would ask about, for example, on A3, the form, A2, the annual report. Right now, that is written as the report that comes from the supervisor. Is that still what would happen? Or is that getting changed in pathways? So I just want to make sure that makes sense in the structure that the board will be looking at. And then I would also question whether or not you would have to actually remove a supervisor, because what if it's the supervisor who says, hey, I'm taking off to Europe for 6 months. I'll see you when I get back. They don't necessarily need to remove the supervisor or want to remove the supervisor, so would that be required? So that's, if we get into more of the specifics, those are some of the questions I would have.
So if I'm understanding you correctly, what you're saying is this may not be a large enough problem right now.
And that's why I'm
warrant
asking the
this.
staff, whether or not it doesn't end up becoming more work to go in and out of inactive status versus the requests for extension that the board is seeing.
If I may provide some extra information. So for instance, when a psych assistant right now, and then their the supervision relationship fall out, so they don't have a supervisor anymore. So they technically cannot practice, right? Because that's the law that governs them. So in the event these cases happen, the only thing that they could do to stop the 72-month to count towards their registration is to have their registration canceled. Otherwise, their time that they're looking for a supervisor will still be active and contributing to the 72 months. And it could create a problem for them, and then it would be more of a concern to whether are they really not practicing because they still have a registration, even though they know that they shouldn't be. So that would be like a concern to us too, that we want to make sure that they understand that, hey, even though you have a registration, you cannot practice, so it's best for you to be inactive. So that is clear for us and clear for the public that they cannot practice with this registration without supervisor.
So I'm wondering if this might not be something we change, rather than going this route, something we change on the criteria that staff can look at and make a decision without coming back to us. If they're, there are certain things that would allow for this, like we say a 1-year extension without coming back to us, but it might be they lose a supervisor or something like this, so that we allow staff, we allow them to contact us or whatever, let staff know, staff marks that in some way or something. I'm just wondering if we need to go this way, this formal, or if there's a way that this kind of an issue is, it seems clear-cut enough. If somebody loses a supervisor, obviously they can't practice and shouldn't practice. And I'm wondering if that might be something we'd have staff review. And I think we have something in closed session today about that, a person who lost a supervisor and then had months of trying to find another supervisor. So our criteria, thank you.
In the administrative procedure manual that's in front of the committee members on page 25 is the current matrix for when we have a delegation to the staff to make a decision.
Sorry.
Oh, sorry.
Might have one.
I'll take Ms. Swart's word
Yeah.
for it.
So we have it written down, and right now what we have are disability under the ADA, care of a family member, and we've talked, and all of these have parameters, injury or accident, parental leave. And we have the parameters of that and the length of the extension. And maybe we could do something, maybe we could do, on page 25, maybe we could do something similar. I'm not sure, maybe we don't need to go this way, so.
Well, I do think trying to do this by regulation, particularly given variables about when
Right.
that Ms. Marks brought up, when exactly does the discontinuance in service delivery happen, and all those types of things can probably be considered better on a case-by-case basis. And then we can carve out those cases in which it would be appropriate for staff to assign additional time because they were inactive. That may make more sense, actually, because as I see, and I really appreciate staff going through the exercise of creating all this language, but I can see how, in order to do this correctly, I think we're going to have to make such a complicated formulation.
Right.
I'm not sure it's going to be very clarifying for either psychological assistants or their supervisors or the public.
I think this will, add more.
Would the committee consider putting this on a future licensing committee agenda to see how things are going and look at the necessity of either language or additional criteria for staff delegation?
Oh, I think it should go on our next licensing committee thing.
Okay.
And perhaps then staff could also bring some of those statistics about the numbers of requests for extensions. And so we had a little bit more hard data to allow the board to see if it's something that would be helpful.
Sure, I'll bring those materials for consideration next time.
So I think the useful statistic from my point of view would be not only how many requests we're getting for extensions, but how many of those involve some period of inactivity that they're asking to be taken into account. I think it's a fairly high proportion, but there may be other reasons that people are asking for extensions. So if we could get that proportion broken out.
And a general reason for the extension request.
Totally agree. And then I think doing that allows the committee still to take those cases that fall outside the parameters given to staff. And so far it hasn't been overwhelming. So. But I don't know that.
Not to the committee.
Well, to that,
Because y'all are doing such a great job.
so I think to that point, I'm curious to know from staff's perspective, by not acting on this today, what are some of the obstacles that will remain in your way going forward to address this potential issue that you mentioned of folks losing their supervisor?
So the best we could do is we will advise the psych assistant, letting them know that you still have a current registration, but you cannot practice. However, your time remain on the registration will still count towards the 72 months. So if you are certain that you're not gonna be able to find a supervisor, you should cancel, we let them know that they can cancel their application. So when they're ready to practice or find a supervisor again, they can apply. So they just have to go through the initial application process for them.
And that's where it becomes awkward, right? Because now we've got them having to reapply for a psych assistant registration and going back through the process again, which means you guys have to go back through the process again. So I can see where that could be problematic. But I don't know that at this point, I don't hear on the committee that we're ready to move forward with specific regulation at this point.
That's fine, because we can continue to discuss this.
So y'all will bring it back to our next licensing committee meeting, and then it'll go, but hopefully before the board then in February, at the February meeting of the board. All right. So we don't have to move to not take action on this or anything. Okay. So is there any public comment about what we've been discussing, Dr. Emus?
It's more of a question. I'm Marilyn Immos from CDCR. We have quite a few people who have a psych assistant license that come to us. And of course, we're an exempt setting like DSH and lots of other organizations. And apparently their psych assistant license is then on inactive status. So let me just do this with an example because I don't know how to ask this question otherwise. So let's say they're on inactive status because they come to CDCR or DSH or someplace else that's an exempt setting. And then let's say for some reason they find a supervisor out in the community and they think they're going to return to that. Their psych assistant license has been on inactive status, not because of disability or loss of a supervisor or something else, but because they're doing a job that doesn't require it. So is there, in this case, also a limitation on timelines with the psych assistant inactive status or not? Or is this a different situation? Have we covered that?
Well, y'all let me know what you think, but what I think is we're looking at the psych assistant registration.
Mm-hmm.
So if that hasn't been adjusted in any way, as far as the board knows, this is still active and it can remain active for X number of months.
Even if they're working at an exempt setting? They generally do.
They would
Right.
need to cancel their.
But let's say they wanted after that.
If they didn't cancel it, my guess is that this would be something that would come back to the licensing committee to review, because a case like that probably wouldn't be something that we would say the staff could review. I think that would probably be on a case-by-case basis.
Okay.
That's what I'm guessing.
But I'm also questioning whether or not there would be any need for review, because if they're in an exempt setting, they're accruing
You're
hours.
saying they go back.
They go back. They would then leave the exempt setting before
Well, I
they're
see what you're
licensed.
saying. Well,
It's
yeah,
possible.
and that I don't know. I guess the question is, how much gap is there? Because if they've accrued hours in that time period that
Right.
they were in the exempt setting, it may not matter because they'll have accrued their hours within the restricted time period anyway.
But they may not have the 3,000 yet.
Yeah, I don't.
And then they wouldn't, and if they ran up against this 72-month limit, they would then not be able to, they'd have to find another way to, another setting in which to get hours that did not involve a psychological assistantship.
That's what I was asking. Okay. Mhm.
But when you use the phrase inactive status, there is no formal inactive status for psychological assistantship. They may
Okay.
be inactive.
Yes.
They may decide they want to cancel the registration at that point rather than have it count against their 72 months.
I see. Okay.
Yeah.
Yeah.
Does that make
All right.
sense?
Yes, it does. Thank you.
Any more public public comment? Okay, seeing none, why don't we move on to the next agenda item, break? Okay, we're ready to take a break now. So let's take a 10-minute break and return back at 10:32. Okay, we're reconvening and looking at item number 6. This is a request from a psychologist, I guess, I don't know, asking us to bring this issue before the board, whether or not face-to-face supervision could be provided by secure video conferencing. So this is a request, if we want to, asking us to bring it before the full board for a discussion. So do either of you have anything you want to say about it? About in terms of, again, I don't think we need to decide anything. It's like, is this an issue we should bring to the board, or is this something that, I don't know, you might have concerns about, or concerns we may want to raise, or whatever. So I'm going to ask you, any thoughts about this?
You know, I do have some thoughts about it. I mean, obviously, we've talked more about doing things that are electronically mediated, whether it be by Skype, or, well, Skype's not a bad example since it's not HIPAA compliant, but by video conferencing means or by purposes of telephone. Obviously, we don't want supervision by email, I don't think, in general. But typically, if I understand correctly, the way that the licensing staff has treated this is that face-to-face means being in the same room. Is that correct?
Yes, that's correct.
Okay. So, I mean, I think this is something we should be thinking about, because I don't know that it really reflects the realities of the workplace anymore in terms of psychologist supervision. On the other hand, I don't know that I'm 100% comfortable if somebody were to do all video conferencing supervision of another professional, that would be the same experience as you would have having some face-to-face supervision. So I have some hesitations, but I'm also in favor of us adapting to the changing times.
Mr. Fu?
I would be curious, while this question is focused on supervision, there are potential implications for questioning coming up on a practice monitor if someone's on probation as well. Is if we could see a potential question of, well, is it possible then to also do a face-to-face by a secure connection on video for for practice monitoring as well. So I think this question could potentially lead to questions related to that. And then I would be curious to know what thoughts of staff are regarding this question in terms of any issues that they would see with this. At a later time is fine. No, this is just a general. If we're moving this discussion to the board, I would love to have some thoughts and opinions from.
To quickly put it in context, I just wanted to kind of advise the committee that the direction of the pathways language is to take away the requirement for the language to be face-to-face. And the language in pathways is asking for just direct supervision and not laying out what that would look like. So I just wanted to put that in context for the committee.
So would pathways in effect, be addressing this question?
I think there's a big debate, or has been kind of a historical debate on what is direct supervision, with not just our board, but other boards. And I'm looking at Ms. Marks for some guidance on how that might be addressed. And we would obviously have to address it in the initial statement of reasons, because we would be changing it from face-to-face to direct supervision. I remember the discussion many months ago was, there was brought up the idea that it could be done through electronic means, but then I think the committee didn't agree with putting that language in the regs, so I'm just not sure.
Yeah, I think at this point, it's just a good discussion to have, which will probably carry over two pathways, and just the attempt to make more specific what the committee wants, and what the board ultimately wants with respect to that relationship.
I think, I agree. I think this is an important issue for the board to talk about. I think we will probably talk about it more in pathways, because even with a secure network, which I would think generally speaking would be fine, it'd be HIPAA compliant, et cetera. It just makes me think, I wonder if we're running the risk of who's doing the supervising, what kind of qualifications do they have. I mean, there's certain kinds of things that maybe, I'm not sure, I haven't thought out all the possibilities, but is it as easy to track or keep tabs on? But I think we do need to keep up with the times. I think we do need to recognize that people do practice differently. And certainly our licensees who are consulting psychologists or IO psychologists or those general applied psychologists, I think they often have a more technological approach, to the things they do, and definitely the federal government. Anybody who's working in a federal government agency, that's across the borders and all kind of stuff like that. So I think it's worth considering and taking a look at.
So how do we frame the issue? Do we frame it within pathways and highlight that as we discuss pathways with the board? What I understood this email to ask for is an opinion from the board as to whether that constitutes. I don't know, we're in the business of giving opinions separate and apart from, and perhaps Ms. Marks could clarify for me, but I don't think we give opinions as to what does or does not fall within our regulations, except within specific situations, but maybe an opinion letter would be appropriate under these circumstances.
So what would be the next appropriate place to bring this? Should we get an opinion letter?
The challenge there is that there are going to be a lot of variations on this theme. I think that staff, I think that because of the variations on the theme, are you getting into areas of precluding certain things that that aren't necessarily spelled out sufficiently in regulation. I think whether or not I'm not sure how much guidance the staff needs on these kinds of questions. I don't know how often they come up with what does it mean to be face-to-face? I know we've talked about it before with whether or not it had to be in real time. I remember that particular question. I think we said direct means, I think, in real time. But that was, I thought, a relatively easy interpretation of the board's own regs. As I said, the challenge is responding to individual questions on interpretation that then aren't necessarily reflected in regulation specifically. I think the pathway, it would be discussed in pathways, right? I mean, I think we've talked about it before. What are the limits, around that? So is staff looking specifically, or I think my discussion with staff is that they were bringing this to the board because the person had specifically asked for it to come to the board.
Yes, that's correct. Just to add on, if we receive inquiries regarding face-to-face, so we'll just advise accordingly per our regulations right now, because we really cannot deviate from that. So we advise them it has to be face-to-face in the same room to provide your supervision.
Although face-to-face could mean, I mean, you could be face-to-face if you were video conferencing, so I'm not sure. I think that's been I know that's been the practice. I just have the gut level feeling this is probably best addressed within the greater framework of pathways, as opposed to trying to carve out this issue. I mean, we could certainly, I think there may be some way we need to highlight it when we go through the pathways material with the board.
Right.
But I don't think we can respond to this particular inquiry other than to say what the current interpretation is as to ours, which is, as I understand it, face-to-face in the same room. Does the issue actually come up in reviewing ours?
If we need clarification, if we have questions in reviewing the form, the verification of hours that they submitted, we will ask them that question.
So what would raise that kind of question? For instance, you could have a California licensed psychologist, we'll use this example, in Florida, and they're signing the form and saying their office address is in Florida, and you know the psych assistant's in California.
Mm-hmm. It would give us a clue to ask that question if they have if they have indicated they didn't provide the supervision accordingly, because I believe there's a question that asks them, have you providing weekly face-to-face supervision to your trainee? And those instances, like especially for out-of-state hours, then we'll ask them that question to clarify.
And that may result, if it has not been face-to-face in the same room, of the hours not being allowed.
Mm-hmm, correct.
Any more questions or comments here? All right, is there public comment on this? Okay. Would you please state your name and?
Yeah, my name is Michael Kellen. So that question actually came from my colleague, Dr. Ruben in Florida. So we have a facility both in California and in Florida. And Dr. Ruben is licensed in Florida and in California, and he spends 2 weeks here and 2 weeks in California. So the question was whether he could provide face-to-face supervision next week, the first 2 weeks of the month, and then the other 2 weeks it would be okay when he's in Florida to provide that electronically. So I guess I'm just not quite sure what the answer was. Was the answer no then from the discussion?
The answer is currently no,
Okay.
as I understand it, yes.
All right. Okay.
Thank you. Dr. Emus, did you want to?
Marilyn Emos from CDCR. Well, thank you. This actually has not come up infrequently with CDCR because we have unlicensed clinicians going out to various institutions to do various similar jobs. We now have the electronic health record that allows access by the primary supervisor to the whole state. So basically, the supervisor can look real-time at the notes and so on. It would be feasible, and we would be happy if this area of the regs would be interpreted face-to-face to include video conferencing. Our video conferencing is also HIPAA compliant, so that we don't have a problem with that either. But because the way our state organization is arranged, this would be very helpful. And if that were to occur in pathways, I would be happy. We have just yesterday a situation like this where we have unlicensed clinicians wanting to get supervision in psychological assessment. And we have delegated supervisors who do that, but we don't have an expert at every institution. So up until now, my answer to them has been that doesn't count for the face-to-face 2 supervisory hours and not group supervision either. Well, you can do it, but you still have to have the additional 4 hours to cover what you need for licensure. So I would be happy to be able to give them different information because it's legitimate supervision by someone who obviously has fulfilled the clinical 6-hour training that's necessary and is equipped to supervise an unlicensed staff, but up until now it hasn't been possible. So if the interpretation could be broadened, CDCR would be happy about that. Thank you.
So this is helpful, the comments that, these 2 comments, for us to consider. Thank you. Did you have something?
Sure. Hi, my name is Renee Pugliati. I'm the Executive Director of CAPIC, California Psychology Internship Council. Besides, I think we should try to expand it as a board, but one of my concerns is that how are you going to control if this person is from within California and licensed by California providing the supervision, or if it's a person from another state? So these are the issues that also have to be addressed. So it's not just a simple thing to do, and which is why it hasn't happened, and that's why ASPVB is looking at it with telepsychology and also with supervision as well. I don't know if you have an answer in terms of where ASPVB is in terms of both practice and supervision, and perhaps this is not the time for it. I don't want to I don't want to put you on the spot, sorry. But I definitely think it's the way to go, but there are these other factors to consider that make it more complicated than some people would think it would be. But I definitely encourage that we consider it and with the proper safeguards.
Yeah, as things stand now, as I understand it, to be a primary supervisor, they would have to be a California licensed psychologist, no matter where they're located. But the question right now is they can't do supervision from out of state for that primary supervision. Those are required to be face-to-face hours.
Can they do it within state either? I didn't think so. Okay.
Not right now.
That's right.
And that's what we are looking at within the context of pathways. We do want to adapt to the changing times. I don't think we'll probably waive the requirement that somebody be a California licensed psychologist as a supervisor for purposes of...
Thanks.
Well, I want to thank y'all for your input because you have given us some good things to think about when we hit this part of the pathways to licensure, and then we'll move on from there. But at this point, this is how it stands. Face-to-face supervision means in the same room.
Do we need to clarify, or based on the memo that there is a action requested, do we need to clarify that we would just include this in our pathways discussion, and is that a motion necessary for that, or can we just, okay.
All right, moving right along here, it looks like we're ready. Speaking of pathways to licensure, we're ready to start reviewing those pathways, including the feedback we got from the stakeholder meetings in Northern and Southern California. So, as a way of doing this, I think we should probably start with section 2909 and take a look at the marked language is what we had been considering prior to the stakeholder meetings. All right. And then the feedback from Northern and Southern California to our specific questions. So let's start with 2909. And our question to the stakeholders was, should there be an exempt status, and if so, who would that apply to and what should they be doing? All right. So what we had, that was our first question, and what we had said is we basically kept the first paragraph, except we added at the end of the last sentence, outside of those settings. And we removed part B from that. So I don't think there should just be an A and no B, but that's technical and that's later. So I'm going to open this up to our committee first. Should there be an exempt status? Who would that apply to? What should they be doing? So, I'm just going to keep talking. Based on the feedback we got, it seems that people thought that there should be exemptions for people who were not basically doing things that would require a license. Research, teaching, at this point consulting, or people who, if they are doing mental health, they're in a setting for a certain period of time where they can be doing psychological work, but only for a certain period of time they have to be on their way to licensure. So it seems that people are in agreement with that. Yes, exempt settings, but the people exempted from getting licensed are people who are doing research, teaching courses.
Well, you know, I do
except
think
for courses that might be teaching applied stuff.
I do think there was some split, actually. There were people that were concerned about the fact that people were using the title psychologist and that would, in these exempt settings, and that in some way this would create a certain amount of confusion. There was also concern that doing research within an academic setting might involve doing clinical research, which would bring people into contact. Although I'm not sure that really comes up in an academic context, in the sense that I think typically, in my experience with academic research that has direct clinical implication, is that the people that are delivering the service are somehow permitted to do so. It's not the primary researcher necessarily that's delivering the clinical service. So
it's the practicum student or the intern or the postdoc
or even a psychologist they've hired.
Or even a psychologist.
So I personally think, based on all the discussion that we heard, that there should be an exemption for people within certain contexts who are not delivering direct psychological services to people, or at least direct mental health services to people, that they should still be able to continue to call themselves psychologists. A social psychologist is a social psychologist in an academic setting, and they deserve and are entitled to, I think, to be referred to as such. So, but I don't, is our language sufficient to that purpose, the language that we proposed? I'm not, I guess part of my confusion is, I know that we carve out school psychologists in subsection A as a result of the fact school psychologists are a licensed category, and they are licensed by another board. So that's it's recognized in our law that school psychologists exist, that they can be licensed, and they are licensed through the Board of Behavioral Science. Do we require any additional language to clarify that people operating in certain settings can refer to themselves as psychologists? Is it sufficiently covered by what we have written here?
That's a good question, because as I read it, it doesn't seem like it's sufficiently covered here. And maybe that part B, I wouldn't say psychological assistance, but people who are employed as psychologists, it's how they refer to themselves in an academic setting. You're employed as faculty. You're assistant professor, associate professor, or full professor. That's what you are. That's your title. Say in an academic setting, you may be doing research, you may be teaching classes, your training may be in a certain area of psychology, and you might call yourself that. Like, I'm a clinical psychologist, but let's say I'm totally in academics, then I'm on the faculty. And
well, you wouldn't even necessarily need a faculty appointment. I mean, there are people that do have research positions.
That's right.
Within universities as well.
And they also have, and that's what they're called, that's what their title is, in the setting, but it might be, it could be research psychologist or something, depending on the setting.
And I think this is recognized by our national organization in the scope of people that are involved in the American Psychological Association across a variety of different parameters, all of whom are psychologists in a general sense of the term, but are not licensed psychologists.
Right.
So do we need to resurrect B and revise it?
That's what I'm now thinking. Because if they are in those exempt settings, if they are providing psychological services like mental health services, or I'll just say that for want of a better word, for want of a better phrase, if they're doing that, then they're only exempt for a certain amount of time, and then they have to be licensed. So it's really outside the scope of those applied services that we would license people for. That's what we want to, I think, say, right?
Do you want to quickly, I know this gets a little bit confusing when we get into this section, but do you want to read 2910 first and then look at 2909 so we know we're not duplicating?
Okay, where's 2910? Okay, you perform the activities as part of the duties for which you were hired. solely within the jurisdiction or confines of those organizations, don't hold out to the public. Yeah,
Well,
there you go. right
that's
there.
problematic,
Yeah,
because they do
problematic.
hold themselves out to be
Yeah,
psychologists, but they're not claiming to be licensed psychologists
That's
who
right.
can provide direct services.
right.
So I actually think that's inaccurate.
It is inaccurate.
If I may, Dr. Phillips, I believe the intent of the not holding yourself out is outside of your setting. So outside of the school setting or the employment setting.
Then I think that needs to be
I
clarified.
do too. I mean, we understand that. And it says that earlier, you can't perform the activities, but you can't hold yourself out to the public by entitled. Yeah.
Students at UCLA are part of the public. I mean,
Or
they're
what?
taking, students at a major university that are taking psychology course and the professor calls themselves a psychologist are members of the public, so this, I don't know that this language really matches.
It's not entirely accurate. Yeah. Because the fact that, a faculty member would do that. So I do think,
So back to 2909.25.
so is there any way, I keep getting confused by 2909 and 2910. Like, is there any way we can combine them into one thing so that we say it's clear, there's certain settings that are exempt, here's what people can do in them, here's how long they can do them. If they're in these areas doing these other things, then they can do that forever. I mean, you know what I mean?
I think that's the whole point of Pathways, is to be suggesting
Yeah.
statutory changes. So I think, the staff has for a long time tried to make sense of the distinction between 2909 and 2910, and it's come to the exempt settings versus an exempt position. Whether or not that makes sense, and currently as you go forward, is up for the committee, and if you think it would be more clear to combine them and not try to make those distinctions, I think that might help clarify things for everybody.
What do y'all think?
I think it's a good idea. Part of what I struggle with is there are exempt settings, and there are people that are exempt because of their status, although they're working within particular settings. I mean, school psychologists are just school psychologists, so they just have,
Right.
they're just exempted from our laws. But a lot of these people are working within settings that permit them to
Right.
have the
Right.
status as being exempted from the law.
So if we combine those and then we could clarify, I think it would be clearer. So maybe this is a section we're going to have to come back to. And maybe staff could
Oh, I like that
be
suggestion.
thinking of some ways to combine.
Sure, we'll do that.
I'm sorry?
Sure, we will do that.
But I think that discussion we're having here reflected the conversations that were happening in Southern California, at least the one that I attended, because folks were struggling with this notion of providing services in 2909, and then we always had to refer back to 2910 to get this better understanding, and so
Right.
it seems like that confusion was in that particular stakeholder meeting as well, and so it may make sense for us to just bring it all together.
I think splitting it up into two different statutes makes it very confusing.
It's very confusing, and maybe, because Ms. Marks, if I heard you correctly, you're asking for some guidance about how you would do that, and I'm thinking, and I don't know, this is, thinking out loud here, but it's dangerous. We might think of kind of saying, okay, here's one situation. This would be in this setting, people can do this, and they're exempt. They can be called psychologists, and and they even can do mental health kinds of things, but they're in this kind of setting that allows them to. In this setting, but they can't do it outside. In this setting, people who are doing these things that aren't really delivery of psychological services, I'm gonna say, they can call themselves a psychologist, they can do all these things without having to be registered, or it doesn't have to lead to license, they never have to get licensed or something, you know.
And
something like that.
to follow up on the idea that we were discussing earlier, and they cannot hold themselves out to people outside of the setting.
Outside. All of this is, within the setting.
Right.
Yeah.
And then school psychologists can occupy their own
Their
special
own-
place.
their
They don't have to be in
special
any
place.
particular given setting, they're
Right.
just school psychologists.
Right. But we don't regulate them, so,
Right.
we're just gonna say, we'll say that in there like we do here. But so maybe that kind of combination. Did you have something to say, Mr. Booth?
I'm thinking on the flip side of it is, what were the potential reasons that the legislature separated these two items? So if, not to dig into legislative history or anything like that, but I would be curious to know if there was a potential reason why they split originally in that way, and by us recommending or thinking about combining these two, if we would be potentially running into any issues there. But that is not a suggestion in any way to start going through the archives to figure that out. But I would be curious as a practical matter why it was separated in the first place.
Ms. Sorg,
She's looking at the book right now.
would you anticipate the legislature would have an objection to us reworking these two sections into one statute so it was clearer?
I think as long as the protections that were laid out initially were still somehow in place, that sounds like more of a clarifying organizational issue than it is taking some things away or what have you. I think that would be more of a concern from the legislative intent side of things. But I was just looking at our book to see when those statutes came about, and it looks like the 2909 was in 1981, and 2910 was in 1967. So that one goes back a little bit more. Curious.
It almost sounds like, based on the order of things, that the same kind of thing we're now grappling with created these two, right? So now we're going to combine it. So is that enough direction, do you think?
SAC would take a stab at it,
Okay.
and then we'll provide some. We probably, if we have it, if we were able to work really efficiently, we can send it prior to the next meeting so that you guys can take a look and review it and bring your comments to the.
Prior to our next
January.
licensing committee
Yes,
meeting?
yes.
Okay. That'd be great.
Okay.
Thank you.
Yeah.
Okay. All right, with each section, I'm going to ask for public comment just so we don't get too far down. So is there any public comment on this issue about exempt status, exempt settings?
Just a little comment, Renee from CAPIC. Mr. Fu, I think it is important to look at why it was done in the first place, why they had one and then we had another one, so we don't miss something along the way and possibly update it, but miss something along the way. So I think definitely it's worth looking into why they did add the one section and then add the other section later. That's all.
Spoken like an attorney.
How'd you guess?
Any other public comment on this section? Okay, then, staff, y'all will bring it back, hopefully, for our next licensing committee meeting. Now we're on, the next section is 2913.
Aren't we 2909.5?
Which one?
2909.5?
Oh, yeah, sorry. I skipped over that after we. 2909.5. And was, I gotta get my different things. Registered psychologist. And our question here, because registered psychologists are actually not licensed psychologists, they are not psychologists. So our question to the stakeholders is what would be a good alternate term for registered psychologist? We had lots of comments, kind of all over the place. The favorite choice seemed to be, at least in Southern California, pre-licensed psychologist. Wasn't there a favorite one in Northern California as well?
Psychological assistant.
Yes. Yes, I think that's a psychological assistant is the Northern California choice.
Okay.
I think in Northern California, they expressed why was this even needed to eliminate that category entirely.
Well, I think some of that has to do with access to service, being able to provide certain settings for these organizations, or certain individuals for these organizations that can deliver psychological services without having to be fully licensed yet because of the nature of the institutions. That's always been my impression.
But will they be getting licensed? Are they pre-licensed? Are they moving to licensure? Are they working as how long does a registered psychologist, how long is that person able to practice as a registered psychologist?
Yeah, 30 months,
Okay.
the registration, and then a prerequisite is they have to have a doctoral degree and they need to have 1,500 hours already accrued.
So it may make sense to call them a pre-licensed psychologist.
It seems like to me, though, that's a broad category. Psychological assistants are also pre-licensed
True,
psychologists.
that's true.
So, I mean, it seems like we're giving them a title that kind of subsumes
Right,
other
right.
categories.
And the thing that distinguishes them is the setting they're in at this point in time, right?
Right. I'm going to go back
We call
to.
them a psych assistant.
We could call them all psych assistants, but we've got regulations that relate to psych assistants, we've got regulations that relate to registered psychologists. The time limitation on registered psychologists is shorter, so I think, I still think conceptually we're going to be better off having two separate titles for it. The one I actually like, just to put it out there, and not psychology associate, but psychological associate, which would parallel the language of psychological assistant, I think in some ways maintains the demarcation between the two categories, doesn't leave you with somebody that's calling themselves a psychologist.
Right.
Even though they're saying registered psychologist, which is appropriate, it's still misleading the public. I've been confused about this title since I was in graduate school.
Yeah.
And
I
I had a
know.
friend that was a
I'm
registered
still
psychologist.
confused
I
about
didn't understand what it meant.
Psychological associate.
So I think just looking at the notes here, the question from Southern California was that we would need to differentiate the degree from BBS. So that's according to the comments below. So which is different though, because they are using the term psychology associate versus what you suggested, which is the psychological associate. But I wonder if that distinction or that differentiation is still needed by changing that word.
Well, I think
BBS doesn't
BBS
use
uses,
psychology
BBS
associate.
uses, don't they use associate clinical social worker?
Yeah.
That's a license.
Associate marriage and family therapist. Everything that had intern is changing to associate. So that, but not psychology.
They don't have any psychology.
Yeah, so I don't know that a psychology associate would be confusing with what's going on.
I don't think so either.
Or psychological associate.
So y'all want to do that? Use that term, psychological associate? Is that what you want to recommend? That that's the term we use rather than registered psychologist?
Does staff have any thoughts on that term?
Okay. Want to give it a try?
Sure.
And we'll explain it, we'll explain things everywhere and all like that. And this is, the registered psychologist is definitely confusing, so. This is clear that this is somebody who's not licensed, but in the process of getting licensed. It's one of the categories for being in the process of getting licensed.
Well, it's as clear as psychological assistant.
Exactly. Clear as, only a little bit differently clear.
Yeah, right. But it doesn't in any way imply that they are a psychologist.
That's right. And that's really the public protection piece, yeah.
Do we have, one of the questions that was asked was, what do other states call this position? So do we have
That's interesting.
they don't have this position?
No.
We're being unique, okay, noted.
One of my concerns I had brought up to staff was whether or not, for reimbursement purposes through insurance, that some of these nonprofits or federally funded nonprofits, that they would need to rely on this term or this title for reimbursement purposes. So I just thought I would throw that out there, that it may be an access issue for those organizations or not.
So I will tell you that this is one thing the American Psychological Association has been working on, because of the training one has when they reach these categories tends to be more than some other training. So the American Psychological Association has been working on this issue to get reimbursement for psychologists who are in, or I want to say individuals who are in training and in the process of being licensed. So it is a large, it's a national issue as well. So
Ms. Sorg,
doesn't mean we shouldn't, but yeah.
to your question, to your point, Ms. Sorg, have we heard from any of nonprofit community agencies that would be affected by this change about that concern about receiving reimbursements? Have we heard from any of them?
We haven't, although we did have some of the nonprofits were on the invite list. I'm looking at Ms. Lim.
Yeah, they're the nonprofit organizations, some of them were invited. I would have to go back to see if they attended. I believe they did not.
Although, were any of the training directors from?
There were training directors.
Yeah, there were training directors, but I'm not sure if they came specifically from the.
Be interesting to see, because I do think that training directors typically are in a kind of nonprofit.
Yeah, we can look into that.
They're not usually for profit organizations. And also, if we do this, obviously we're going to be putting this out there for public comment. And if it looks like it's going to have serious ramifications, we can rethink it. But I do think, no matter what the situation is relative to reimbursement, I do think it's important that we move away from this label of registered psychologist. Because it
No matter
is
what,
awfully
yeah.
confusing. It sounds like a licensed psychologist to me.
Exactly.
And to be
One
clear,
form of licensure, yeah.
and that term isn't being referenced in federal language for reimbursement at this point that we're aware of. I'm just curious.
Nobody else has it.
That's right.
We are California. We're terminally unique.
Okay, so that's our suggestion to change this section. Is there any public comment on 2909.5? Mr. Pugliati?
This is so much different than my day job, and it's a little bit refreshing, but sorry. I think one solution towards your concern regarding reimbursement is to include a line or a paragraph that defines that a psychological associate is equivalent to whatever term is used by either the federal government or by insurance companies for reimbursement purposes or for grant purposes, something like that, to make sure that we don't lose that important distinction for these people. That's all.
Thank you. Any other public comment about this? All right, seeing none, let's move on to, now we get to go to 2913, services by psychological assistants. Our big question here for the stakeholders was, should board-certified psychiatrists be allowed to be primary supervisors for psychological assistants, since they are not required to take the 6-hour course in supervision, are not subject to any other of the psychology regulations, and they do not promote the kind of socialization into the field of psychology that might be more applicable to psychologists. So that was our question, and here were the answers from Northern and Southern California. That was our first question for 2913. And I think, if I'm reading it right, and y'all can correct me, the major concern was, would this be hurting psychologists who were already in the pipeline and being supervised? And would it be limiting their opportunities to get supervision? My sense was, as we talked about them, psychiatrists still being able to be delegated supervisors, and that people felt better about that, and thought that perhaps because we really couldn't regulate them and couldn't make demands on them. I think one of the things that was brought up was like, well, which ethics code? Because we are required to follow the code for psychologists. They don't have the same ethics code that we do. And so things like that when it came to questions like that. So I think the general agreement was that psychiatrists, board-certified psychiatrists, should not be primary supervisors. They can be delegated supervisors.
And I guess the one question that was raised that sticks out in my mind was, what happens to people that currently have primary supervisors who are psychiatrists under, for instance, their psychological assistantship? Are we somehow, do they need to be somehow grandfathered into the plan?
So at this point, we're looking at 2020. Psychiatrists are only allowed to be primary supervisors for 750 of the 3,000 hours. So I think we have plenty of time to educate people about this. That's roughly 6 months. I mean, if we consider 1,500 hours a year, and so my sense is we would have time to educate people. This is coming. It will go into effect. That's what I think. That would give them the time they might need.
And if I recall from the statistics, there was a fairly limited number of
pretty few
psychological assistants that had primary supervisors who were.
Yeah, it's about or less than 5%.
So I think allowing for that time, as long as we were to educate people
right.
sufficiently in advance, I think that'd be addressed. And I think it becomes awkward grandfathering people in. It becomes a kind of unwieldy, even from an administrative point of view.
Because we do have so much lead time, I think that would be.
And I think the point that was most persuasive to me, because I was originally concerned about this particular change, the point that was even beyond the ethics code, what was most persuasive to me is that part of the experience of having supervision is to be familiarized with and acclimate to the culture of psychology, the way that psychologists think, and with all due respect to my psychiatric colleagues, it's a very different culture and a very different way of thinking about things. So I think this is a good idea.
So we're okay with this part of it. So we had another question, and then I'll get to any public comment for 29, well, we had a couple more. What would be the ramifications to remove board-certified psychiatrists? And we may have already answered this. Would the board be limiting supervision opportunities? I think we've already answered that. Should a psychological assistant be allowed to advertise? Why don't we take the psychiatrist part first, and then let's talk about the advertising part, because that was a more complex discussion, I think. So the licensing committee has removed board-certified psychiatrists from the as being able to be a primary supervisor. That's going to be our recommendation to the board. Is there any public comment on that? Okay, seeing none, let's move on to now the next section of 2913, which was our question. Should a psychological assistant be allowed to advertise, considering they are not allowed to practice independently? If so, should there be restrictions in how a psych assistant can advertise? What are the restrictions? Can a psych assistant have a website? So there were, as people can see, a lot of comments on this. It became a pretty, I think, as people began to consider it in both Northern and Southern California, it seemed to raise a lot of issues, a lot of complexities. So I'm going to throw it open to y'all first.
I think there are a lot of complexities to this. We're working on pathways to licensure. Arguably whether psychological assistants can advertise or not does impact someone's pathways to licensure. I almost feel like, however, that this is really more an enforcement issue in some way. That enforcement might be able to better inform how to do this in a way that would best protect the consumer as opposed to the licensing committee. So I almost feel like we should defer this to enforcement personally. I'm in favor of allowing psychological assistants to advertise, but I think we need to do it in such a circumscribed way that we make sure that consumers are well aware of whose services they're retaining and that that person's doing it under somebody else's supervision.
I'm sorry.
Because we are putting our psychological assistants at a severe disadvantage in the marketplace compared to other licensing categories. Now, that can't be the sole consideration, but if we don't need to put them at a disadvantage, and we can adequately protect the public, then I think it would be appropriate for us to consider making changes in this regard. But my gut level feeling is maybe this is more an enforcement issue.
I like that suggestion. I mean, it may come back to us, to the licensing committee, because it may go into pathways for licensure as one of the things that psych assistants can do, or not do. But I mean, we would address it in pathways to licensure. But I agree with you. That's really something that maybe the enforcement committee should think about. What would be the appropriate parameters to put around this, Mr. Fu?
Oh, I was just going to say, and Ms. Monterrubio is up here, the board is going to be convening the enforcement committee next week, and this is on the agenda for the enforcement committee to look at. I was going to suggest that what we do is we include the stakeholder input as materials for that discussion, because I think it's really helpful resource to see what was the input from the group at the time. And I know Ms. Monterrubio was there for both discussions, so it'll just add some context to the direction of what the committee would like to do.
That's great. We can definitely do that. We've actually already drafted language that we'll discuss at our meeting next week. So I agree with you. It's probably more enforcement related than licensing at this point. But I'll be sure to include the stakeholder information.
That's great. Thank you so much, and I think that's really a good idea. I'm glad y'all are way up on it.
And then
you knew that when you said...
No, I didn't actually. Then the licensing committee can look at it within the context of the greater pathways to see how it all fits together. Right. But I think that'd be great.
Absolutely. Mr. Fu, did you have anything you wanted to add to that? Nope. Okay. Any public comment about this issue? Okay. So, seeing none, We are moving right along now to section number 2914, and applicant's requirements. All right. Here was our question. This is, we had talked about changing this to essentially applied areas in psychology, or in education in certain fields that are applied. But our question to the stakeholders was, by listing the fields of emphasis, that is, these specific fields in applied psychology, would potential applicants be excluded for licensure, and what qualifying degrees would be left out, and how would this impact the field? And there we go. We had a lot of comment about this. I think in general, if I'm reading it right, people thought it was a good idea to narrow the educational requirements. In Southern California, I think they were definitely more in favor of that change, those changes. But there we go. Yeah.
I think in Southern California, the question was this notion of general applied psychology.
Mm-hmm.
So it was actually, I think, potentially a widening of these thoughts rather than narrowing that. Would there be an impact on a person with a general background?
Well, we've actually already listed general applied
Right.
psychology. We just didn't call it that in
Right.
our recommendation. Somebody in Southern California suggested limiting it only to clinical counseling and school psychology, and that's health service psychology. And then people said, that's not fair, because maybe we said it, because we have a general license. We license more than those three categories. And so then that's when they said, we'll use general applied psychology for the non-health service psychology. And these are terms of art, general applied psychology and health service psychology. So that's what's used nationally and actually internationally. It's used in Canada as well. So I don't know if we want to use those terms, but I think we have spelled out what those terms encompass in what we're recommending.
I thought one of the concerns, I'm sorry.
I was just clarifying, a quick question. You mentioned that those terms are used nationally and internationally.
In Canada, in the United States.
Yeah.
Yeah.
It's transnational at least. And so do you think it would be helpful to include those terms
Well,
as
that's
a
what I
reference
don't know.
point?
I'm kind of asking that because I mean, people know what those terms mean. They know what it encompasses, but I don't know if that would, maybe if those terms ever change, although I don't know if they will, but, I don't know what's appropriate for our.
I think when it comes to language changes, from the staff perspective, if I could be devil's advocate, you always have to remember it's going to be the licensing analyst that's going to be looking at the qualifications. So the more predictable and easily to understand it is for staff, the better.
I do think we can fall into the following situation, though, and I don't know if it's anticipated by the language adequately or not, and that is that the program calls it something strange.
But those are the ones I think that get sent back to us That's what we've said, that
So
we go back
this would
to.
allow us the flexibility
It allows
to
us the
look at those
flexibility.
particular situations, to determine if they're comparable to the fields that we've set out. I just want to make sure we have that discretion.
So that's what we said, actually in our regulations, and that's what we decided as a committee, that if it's not clear to staff, then, the board has it comes to us, but the board has the final say, so we put that in there, so.
There's one other thing I wanted to mention, and that was, there was a general idea introduced, and I can't remember specifically who introduced it, might have been one of our professional associations, the idea that we shouldn't be limiting down to certain categories, because somebody with a degree in psychology, if they can go out and get the training to get the hours, then that should be sufficient. And I think, Dr. Warren, you and I were in agreement, perhaps Mr. Fu, that we want people in programs where the curriculum is designed to prepare them to be a licensed psychologist, not that they're being prepared to be a social psychologist and they decide they're going to go out and get 3,000 hours of experience.
Right.
With all due respect to social psychology, it's not a licensure eligible field in my mind. So, and this is really to address the conundrum we had before, which was you could pretty much have a doctorate in a variety of different areas, and as long as you had the training, it was sufficient for purposes of getting licensed.
As long as you had the supervised experience.
Right, which is not, not a comfortable situation from my point of view. We want people that go through a curriculum that prepares them for it.
That prepares them. So, we're okay with our current language then?
I am.
All right. For this part, so we have identified the areas of psychology that are I'll say, most prominent applied areas, and the areas in education that are also applied areas. Is this where we also say that, but we already have this, we don't have to do this as a regionally accredited institution at this point in time in this. So on this part, the degrees, I'm going to ask if there's any public comment about this part.
Hi, again, it's Renee with KPIC. I want to get some clarification. Are we looking at saying for the clinical programs, these are the tracks for licensure, and then the applied ones are the ones that are not for licensure or not being covered by the board, or am I misunderstanding it?
We've actually identified
Counseling school and clinical.
Clinical, counseling school, consulting, forensic, or industrial organizational psychology, or in education with the field of specialization in counseling psychology, educational psychology, or school psychology.
So it does cover some general applied psychology
Yeah.
disciplines that
Okay.
typically people can be license eligible for.
Okay, because I heard from the Southern stakeholder meeting that there was some talk about restricting it to school, counseling, and clinical.
That was what somebody suggested.
Okay.
And we said, no, we have a general license.
All right.
We don't, it's not restricted to that. And these general applied folks, it is applied. They are
Right.
learning how to apply psychological principles in different kinds of settings as well.
Gotcha. Related to that is, we have, all of our programs are clinical on some level. Some of them are forensic, but they're always clinical forensic or applied clinical psychology. So, because that's why we got approved by the board. It's because we have criteria that we require coursework and the like. I just wanted to be careful that that something wasn't changing, and it doesn't sound like it is at this time. The other thing,
I think we're clarifying.
That makes sense.
Appropriate training, yeah.
Thanks. I had another question, and it wasn't really mentioned at the stakeholder meeting, well, it wasn't just as a specific question, but in the regs, lines 349 to 353, which is under section 2914, and basically says that no educational institution shall be denied accreditation as an academic institution solely because its program is not accredited by a professional organization of psychologists, et cetera. And I understand that's partly required if we're going to be looking at, I know you guys are still looking at regional accreditation and accepting that along with national accreditation.
It's going to be regional accreditation.
Right. My concern is that we be careful about restricting it further without looking at the evidence of
Program accreditation.
the program accreditation, without looking at what's the actual consequence, what's the actual training that's being provided by these programs, whether or not they're accredited regionally or nationally, and that we don't make a decision without looking at the evidence of both the results and the impact on the profession. I'm very much concerned because KPIC is getting pressured, feeling pressures from APA. The reality is it's also because of the overall pressure in the market, but with the APA's rules, it's pushing a lot of our schools to go APA only, and so they're not going to our internships, and it's hurting not only KPIC's ability to fulfill its mission, but also our internships to serve our California communities. And I think it's partly because of these, the reliance on a stamp of accreditation, which has many good points to it, but I think that there are alternative paths that have to be looked at based on the evidence. And I'm just that.
I don't mean to interrupt you, but we're not going there. So we're really
Okay.
just talking about regional accreditation for an institution.
And
Okay.
that's been set by the legislature,
Yeah.
Right.
not by the
Yeah.
Board of Psychology.
Not by the board. Yeah.
And I'll talk to them when it comes to that point, but hopefully it won't come to that point. Sorry to, I just want
It's
to,
okay.
I just want to be looking out for not KPIC, but also our communities that we serve in.
And to clarify, we are not saying, we're specifically saying it's not the case that you have to be approved by the committee of accreditation.
I understand, right.
That's right.
So it's that the legislative framework is going to cause institutions to either get regional accreditation or to stop having license eligible
Programs, right. I agree, and I guess I'm looking forward, that's all, I'm just trying to be careful. No one can know and no one can know the future, I got it, thanks.
Any other public comment on this particular part of 2914? This particular question we had. All right. So we're going to keep it as it is with those suggestions. And that will be clear to staff. And if y'all have any questions, then it would be appropriate, starting in 2020 or whenever we do, to send those back to the licensing committee.
Does that feel like improved guidance to you?
It definitely gives us more guidance in terms of what degree will qualify should this become effective.
So I don't see it right now, but somewhere in here we talk about the degree and say, I think for general applied psychology, we've said it only if it's not clear what area of psychology that it may require a certification or something like that from a director, the registrar or something like that of the college. But that should not only be for general applied psychology, it should be for any area. Because a lot of times people just get their, it says doctorate in psychology, but you may have to find out what area. So I think we want to make sure that we include that anywhere. I don't remember exactly where it was, but if it's not clear from the transcript what area of psychology, then they would need to provide a letter.
Is that in the regs?
It's in the regs? Oh, okay. All right. So we're not there yet. All right. Our second question about this statute was, are the listed fields of emphasis adequate to ensure consumer protection and access to care? And those were the areas we had listed.
There was a concern expressed in the tenor of these comments that somehow we were trying to dictate the curriculum or what courses
Right.
needed to be taken. That's not at all the intention behind, so people understand, it's not the intention behind these proposed statutory and regulatory changes. It is to make sure that people are getting an education in applied psychology that makes them license eligible. Not to try to say this school needs to do that or that school needs to do this. We're not going to be managing at that level, nor do we have any desire to do that.
Not any desire, we're not looking at courses. And actually, number 3 in the requirements, you know, we've talked about in psychology and education. And number 3 is, or a field of specialization designed to prepare graduates for the professional practice of psychology. And that's our interest, that it's the curriculum is designed to prepare students for practice, basically. No going through courses and looking at syllabi or anything. All right. Where are we next? Are we done with this part? I think we are. Thank you. Any public comment on question number 2? Are these areas sufficient to protect the public, basically? Okay. Seeing none, except head shaking, yes. We will move on and stay with the language we have there with good comments. You know, I just want to say if anybody from Northern or Southern California is watching who came to our stakeholders meetings, we really do appreciate, I just want to say once again, I think these meetings were extremely helpful to us. They really gave us stuff to think about, and y'all can tell today how we're paying attention to your comments, really trying to go forward and think about what's the best way to proceed. So I just want to thank you again. You know, you took out a whole day of your busy schedules, but this has been extremely helpful. All right, so are we on 8B? Let me see here. Get my agenda out. Oh no, we have all the different areas now. Applicant requirements. Now we have continuing education. So that's 2915. Do we want to take these as well? Did we get, oh yeah, we did get input on these. Sorry about that.
So where'd you go?
No, I'm looking at 8A still.
Oh,
Okay, sorry, I just was looking at what we had in our attachments from the stakeholders meeting and got to go back to, you see what I'm saying?
Yeah.
Okay. So it's a little confusing here. So now we're on 2915, which is continuing education. What time is it? It's 11:52. I'm going to propose that we break for lunch right now rather than get into this. It's at a good stopping place. And come back at 1. All right? So we're going for lunch. We're stopping the meeting. We will resume it at 1 o'clock. Thanks, everybody. And we'll go to 3:30. Phones off.
Pull down the audience. Keep them quiet.
Thank you, Mr. Okay, so we are back in session for the licensing committee meeting. I want to welcome anybody from the public who might be watching our webcast here. I'd like to give a little shout out to Ms. Winkleman, who I know is probably watching, and I saw a little blurb about you in the American Psychological Association's practice director newsletter, so congratulations. All righty, we are moving on now to 8B, is that correct? And in the agenda, and the first thing, and again, we want to take a look at these different sections now in regulations that we had questions about and we brought to the stakeholders meeting. And so we'll start with the one-time pre-licensure coursework requirements, which we brought to the stakeholders meeting. And we asked the question, are these topics still necessary? So in retrospect, that might not have been exactly the question we should have asked or wanted to ask, but we did ask the question, are these topics still necessary? And number two, would the 6 hours be adequate for exposure to each of these issues? For those of you who don't know, may not know, one of the things we did in Pathways to Licensure was take all these courses that have been pre-licensure requirements, and we decided to change them to make the length of training and the types of activities that would count for that training all the same from one title to the next, so that people aren't having to take 7 hours here, 15 hours there, some by coursework, some by another kind of work, and all this kind of stuff. We gave people options, similarly to what we did with AB 89. So that said, we got, again, a very wide range of answers about, are these topics still necessary? And then again about, is the 6 hours adequate? So I want to throw it open because I didn't really see any consensus. I mean, nobody was, I think, saying at all, no, it's not necessary to have these courses, or no, these aren't important courses. Nobody was saying that, but they were saying things like there are a lot of important courses, we might want to consider other courses, et cetera, et cetera. So I just kind of want to throw it open to your thoughts about what you took from this and how we might want to go. If y'all don't have anything to say.
I do. I think everybody wanted the justification, or a lot of people asked for the justification for us having these courses. And obviously a lot of these are driven not by the board, but they're driven by the legislature. And they come up within a specific context. So I think one thing we can do is to systematize this in some way that it's at least easy to understand what the requirements are and how many hours are required to have it. It's supposed to have 15 for this and 10 for that and 3 for this. It'd be nice if we did have a uniform system. I don't particularly object to any of these. I mean, for instance, aging and long-term care obviously impacts us all as human beings, and also impacts our population. Even if you're dealing with young adults, they have parents that are aging and they're going into long-term care and so on and so forth. I think they're fairly important topics. It's not to say that there aren't other important topics that could be included in this list, but I don't see any reason. I think these are all important areas of competence, I guess is what I'm saying. And I don't understand why the distinction is made between pre-licensure and post-licensure, but I guess that's also a function of the legislation, I suspect. So 3 of the topics for people that were license at the time they came into effect, they had to take continuing education. That's all kind of come and gone. Anybody that's gone through that system and has been licensed already has already done those. So we're really talking about as a pre-licensure coursework requirements. And I do think in some ways these are things that are not necessarily addressed in psychology graduate school, depending on the program you're in. For instance, in reflecting on my own experience teaching in graduate schools and having attended graduate school, there was very little talk of alcohol or chemical dependency in the programs that I'm familiar with. Now, there may be in other programs, but psychologists don't tend to focus on chemical dependency as much as people do at a master's level. We tend not to work as often in that environment of a rehabilitation facility, or if we do, it's at a relatively advanced level in the facility. So I think that one in particular I like. Human sexuality is particularly close to my own heart, so I certainly see that as appropriate. Child abuse assessment and spousal or partner abuse assessment, you do get a fair amount of child abuse assessment training typically in your applied sites, because they're very concerned that they want you to be able to make sure that you're making the child abuse reports. Spousal or partner abuse, not so much, because we're not mandated reporters unless there's an age differential or somebody's a dependent adult. I can see a justification for including that. Aging in long-term care, again, I'm not sure how much people are actually getting that in graduate school or not. So I can see the justifications behind these. Some of them I feel compel me more than others, but that's not to say that we have much control over that unless we're going to push through a major legislative change, which may involve multiple boards, because other boards are required to these things. And truthfully, from a political point of view, these things have appeal to a politician or a legislator. That is certainly understandable. They don't want to come out against training in partner abuse or spousal abuse. So I think the most impactful thing we can do is to systematize the length of training that we're requiring, to the extent that the statutes allow us to do that.
Beyond that? I agree with you, with both of you, actually. And I would ask the question about the 6 hours. Do you think, that was something specific? Of course, we got one answer, I think, that said 1 hour would be enough, which I don't think any of us would agree with that. And it may have been said kind of sarcastically as well. But our reasoning when we said the 6 hours is because that would be a day-long continuing education course if somebody decided to go that route. And so that's sort of was our thinking. Do you see any reason to change that?
I think 6 hours makes sense, both in terms of just the economy of being able to how continuing education courses are typically set up to start with, and I think that's sufficient. A day's worth of exposure to it is sufficient, I think, to our purposes in terms of heightening people's sensitivity and giving them some basic information about the subject areas. I don't know that a 15-hour course necessarily is that significant an improvement over that, unless you're specifically going to work in that area, in which case you probably want to seek out additional training anyway in order to be competent to work in that area.
And in which case you probably also had additional training in that area. So at this point, I think we're agreeing that we want to make everything the same. It's 6 hours. We give the different options. It can be a CE course. It can be a part of a course in training. It can be part of applied experience, supervised experience, and those would be the 3 options for any of these areas. And I think we also added something about the ethical, something about the ethics piece to this, what the courses focus on, and I think we made that consistent as well. assessment, intervention, ethical and legal issues related to practice in this area. So we even made the course content similar in all the areas. Thank you for turning that up. I forget I can look at the screen too, so.
I know there was a concern expressed during the discussion in the stakeholders meetings about the expense of meeting these requirements.
Mm-hmm.
I think by the way that we're modifying the statute to allow people to get it through applied experience, a lot of those, I think it's actually going to be easier for them to meet the requirements now than it would have been in the past where it specifically required a course that they had to take.
And some
because-
courses significantly longer than.
Yeah, I mean, I can think of or training sites I was at, even as a practicum student, that gave me enormous training in some of these areas.
So we're keeping it as is, and these are the ways we've, any public comment about this area that basically takes a look at all the required courses? So it's 1382, 1382.3, .4, .5, and .6, pre-licensure coursework. Seeing no public comment.
Sorry. Really quick, I noticed that 2915.7 is not in the statutory section, but that is the CE course for the aging and long-term care, which we have removed from the regs, and that requires 3 hours. If we can just make sure to include that in the meeting materials for the next meeting so we don't miss anything in all the requirements.
Thanks. All right. Shall we move on to 1387, supervised professional experience? And here is our big question here. Our question was, currently a maximum of 44 hours per week can be credited toward SPE. What is your experience regarding the maximum SP hours claimed per week? Should the maximum hours that include the additional 10% of supervision be capped at 40 or 40 hours? Would a 45-hour per week maximum, including supervision, be a better option? That's how we framed the question. I think or the questions. I think the issue is there's a lot of confusion about, is the supervision included in the hours worked or counted toward SPE? Or is this outside of the number? Is the supervision outside of the number of hours that we count toward SPE?
I also thought the confusion was, is 10% part of the 100% or
Right.
is 10% above the 100%?
Right, I think I was saying that.
Okay.
Same thing. Just in a different way, but
Yeah.
that's it. If there's confusion about the 10%, about the percentage, and then where is it? Is it within the total 100%? Is it outside of the 100%? And then 44 hours is the 100%, or, So some people have interpreted it that way: 40 hours of work, 4 hours of supervision for a maximum of 44 hours. So it's confusing.
If I recall correctly, there was an interesting split between the two meetings, in the sense that in Northern California, the concern was we were limiting the amount of hours that that people were going to be expected to work more hours than that in any event, and to cut back on the number of hours they'd actually get credit for SPE was doing a disservice to the trainees. Whereas in Southern California, and you'd actually expect these to be flipped, they're more concerned about limiting things to a 40-hour work week and what the state labor laws require. and
As a
those-
protection of the trainees.
Yeah,
Yeah.
which I think are valid points.
I mean, I think we do need to think of that. You know, trainees, it's not, I mean, they often work for no pay or very little pay. And I think, you know, this is a real concern. Where should the board come down? What's protective of them as the public as well?
And I guess the question in my mind is, let's say we restricted it to 40 hours maximum you could get SPE.
Right.
I don't think that prevents an institution from requiring the work.
Oh, not at all.
So I'd almost rather see them, I don't want to create an incentive for them to have to work additional hours, but I certainly want to credit them for as many hours as is reasonable. I mean, we're not going to give them 60 hours a week because somebody's working them to death, but I think the 44 hours in some ways is more to the benefit of the trainee. Unless people believe that the institution would observe the cutoff at 40.
If the institution doesn't, it could be, the phrasing would be at minimum 40, but no more than 44.
And then is this, I don't think we have to say at minimum.
We don't have to
because-
minimize,
We
yeah.
don't have to give them the bottom line. But, because they don't have to be full-time. I mean, they're just getting a supervised experience. But, I mean, let's think this out. Would the 10% of supervision, would that be within that total number of hours? I think it should be. It should be counted toward SPE.
So it'd be 90%, 10%?
I think supervision is part of supervised experience.
Oh, I
Or
would
should
definitely,
be part of supervision.
I would definitely agree with that. But are we using the calculation 100% of the hours and 10% above that as supervision?
Mhm.
Or it's 90%
10%.
delivery hours, 10% supervised hours? That's my personal preference. I think you get more supervision that way.
Mhm.
I think also to the extent that an institution is going to overwork a particular trainee, and I'm not accusing any institution in particular. I know a lot of them are very careful about how their trainees are treated.
Mhm.
That would also incentivize them having to give additional hours of direct supervision. So it would also create more workload for the supervisors. So in a way, it would disincentivize overworking the trainee.
So with
No,
that,
because they're not going to be able to count
Oh, you're right.
any but what we do. So I don't think this serves as any kind of disincentive at all.
You're right.
They just don't get to count it. But I think that supervision and that time spent in supervision is actually an important part of supervised professional experience. So I do think it ought to all be within it ought to be 90%, 100% if we say 10%.
so
But we should cap that hours.
So we would cap it, and just language-wise, it would say we would drop an additional part, because it would be a 36-4 split versus a 40-44 split, which is 10%
Right,
of
right.
40, rather than an addition of 10 on top of 40.
Right. If we want to say 40, if we want to say 44, or if we want to say 45, I mean, whatever.
It would
Still
then it would have to be
90%.
4.5 hours of supervision and 40.5 hours of service.
Right,
delivery, whatever
right.
it is.
That to me seems clearer, and it's all within the supervised experience.
There's some
Y'all are
interesting
smiling, so
expressions
what
from
do you-
the
what-
staff gallery.
What are y'all smiling about?
I think staff is comfortable with, for example, if they see 40 hours work, like that they claim, and then they're looking for 4 hours of supervision. So that's pretty clear to staff. It is the increments in terms of not a full hour, those are tricky. So for example, I work 32 hours. So do I get 3 hours and 3.2 hours of supervision? Right?
Mm-hmm.
And that should be it, because that's how it's written in the regulation. But usually they will do more because they don't fill out like 3.2 supervision hours on their verification. They'll just put full.
So that they get,
Yeah.
they get an extra,
They would
Point
do,
eight.
yeah, because, they won't do the point, the decimal
Right. They
time
don't
of
stop
the-
at the point, they go ahead and get another hour.
They'll just go to the full hour, because it's, I think, easier for, in practical terms too, for
Does it
supervisor.
mean they're actually getting that supervision, or they're just rounding up?
The supervisor verified that, so we are in trust of the supervisor that they're providing that amount of supervision.
I will tell you, since I got on the board and came to understand how the 10% rule was interpreted, with my psychological assistant, I was doing like 0.3 hours. If you had 13 hours of service delivery, I was doing 1.3 hours of supervision, and we just scheduled for it. So, and obviously all the paperwork went through, because he's now licensed. So we could do it that way. It's probably not, it's more workable in a psych assistantship than it is where people have allotted time in a work setting. Let's say there's a supervisor and they've got their supervisees scheduled 6 supervisors in a day, or 6 supervisees in a day. It'd be difficult to kind of try to start to move that line around. I see that you're shaking your head, Dr. Yeah.
Then how do we phrase it? I mean, what you're saying is that people do, they're attesting that they actually give an extra hour. They don't do it that way. And I think most people would go for the full number, you know, whatever that full number is. And we could say in here, any fraction of an hour would add an extra hour. I mean, but
that seems to me that now we're requiring more than 10% supervision. The reason I changed over to the system was I came to understand that the staff felt that was sufficient to meet the rule.
mm-hmm.
And I think part of the reason people go over the extra hour is not because they necessarily desire to do an extra hour, because they think that's what the rule requires.
So we have to be clear at what's being required. So
Right.
maybe percent is not what we want to say. But then how do we, what do we say?
1 hour of supervision for every 9 hours of...
For every 9 hours of work? And so for a maximum of 45 hours then? I mean, what do y'all think?
Wait, what is that? Oh,
Yeah, it's 90% and 1%. So it's a maximum of 45 hours if we're thinking 90, and all of that is called SPE, and that includes the supervision time. And so it would be a maximum of 45 hours. And they're still going to come out if they don't work 9 hours but work, 12 hours. It still comes out as a fraction. So, I mean, there's no way that it doesn't come out a fraction, no matter what we do. So I think we want to be...
Well, if you did 9 hours of delivery, you're going to get 1 hour of supervision. If you did 18 hours, you're going to get 2 hours of supervision.
Right, but if you did 12 hours...
You'd get 1 1/3 hours of supervision.
That's what I'm saying.
Yeah.
It still can potentially come out in fractions.
Which I don't personally object to, but it may be difficult in an institutional setting.
That's what I'm saying.
Yeah,
There we
okay.
go.
Okay, we're on the same page.
I mean, I think we have to think, you were saying initially, I think the same thing, right? In certain settings, that would be difficult. People aren't going to have point some odd hours that they can give to this. They have scheduled their supervision times maybe on the hour or something like that, and they're doing so much of it. An hour of supervision is way easier to schedule in virtually anybody's schedule than 1.2 hours.
Not to obscure the issue, we're also talking about an hour of supervision. It's an hour of supervision like the therapeutic hour? So it'd be like 50 minutes? Or are we talking about?
Let's not obscure it.
Okay.
No, we're talking an hour.
Can I throw out some language?
Sure.
Mr. Glassbeagle? We're just gonna throw this piece of spaghetti against the wall and see if it sticks. So of the total hours worked, this is for number 4. The supervisor, parens S, must supervise the trainee 1 hour for every 9 hours worked each week. And then when it gets to the time spent in supervision, a maximum of 45 hours per week instead of 44.
Okay, and again, we're still gonna have pieces of, there's no way to get around, I think, everybody's not gonna work a divisor of 9 or a multiplier of 9. So there's still gonna be, people are still gonna have to figure out how to do this, and they're likely going to do it the way they're doing it now, is what you're saying. That's what you find, that people tend to. So I don't think we need to require it if people can do thanks, by the way. If people can spend that partial time, if the person isn't working some multiplier of 9, that's fine, and if they can't, they'll add the extra time, but it has to be, must supervise 1 hour for every 9 hours worked.
Right, it's not a
Period.
ratio, period.
I'm sorry, yeah, period. Time spent in supervision can be counted toward the trainee's SPE. A maximum of 45 hours per week can be credited toward SPE. Okay?
I have a random, kind of probably dumb question. How do you hit the total 45? What, give me a fraction that you gotta have in, because if you do 36, that's 4, it's 40. And then you're up to 45, you do 5, so you're gonna have to do 4 points.
4.5. It's a little bit easier to explain at 4.5 than it is to explain at 4.4.
Yeah, okay.
4.4 and then 39.6 hours of service delivery, I mean, it's...
Yeah, 4.5, okay. Okay, cool.
So, all right, so that's what we want to say. Now it also says, we have a for example here. A trainee who works must receive blah, 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 blah. Do we want to?
Yes.
We have to say that one of those hours must be with the primary supervisor, right?
Yeah.
They can be in other formats, but one has to be one of those hours of supervision must be individual supervision with the primary supervisor.
Yeah, my thought was just to take the language I
Right.
after all this is done, integrate it into
Right.
the 3-4.
Exactly, but let's not do the numbers there, maybe just say, we've said a maximum of 45 hours per week can be credited, and then we give the example, trainee who works.
40 hours per week.
Yeah, you can leave the 40 hours a week. Huh?
That works.
Well,
No, they have to receive 4 hours of supervision.
no.
So losing me to algebra 1 here.
So 40.5, 4.5, or do you just use 36.40? That
We
might be
could
a
do
clearer
36.40,
example.
yeah. So then it's a maximum of what?
Stephanie's rubbing her forehead.
A maximum of how many hours a week then?
Well, if it's 36 and 4, that's 40 hours.
Well, that would be the example we would
Right.
give.
Yeah.
But they could work
And
more
we're
up to
saying good luck
45.
on the rest.
You could do range, like if you work X number between 0 and 10 hours a week, you get to do this. Between 11 and 20 hours a week, you do this instead of 1 to.
You do percentages?
That's a table. Because you could say 31 to 40 hours, you have to do 4 hours, and the total number of hours plus supervision can count towards SPE. So then you're still your 44, it's still an even fraction, or for your percentage. Still the 10%, so I think it's right coming out.
But they're getting less supervision.
Can I repeat
No,
that?
it'd be the same amount of supervision if you still want the 10%, right? If you say 0 to 10 hours is 1 hour.
It'll be 0 to 9 hours would be 1 hour.
Yes, but I think what Noreen was saying was go back to 10 and do 0 to 10 is 1, 11 to 20 is 2, and then up to 40, and then you have your 4 hours, and then you're up to 44.
But I think from a policy point of view, we decided we wanted a 1 to 9 ratio for supervision. So, but we could still use Ms. Mark's suggestion, but just make it 0 to 9 hours means 1 hour of supervision. You know, but I guess it'd be 9 plus to 18 would be 2 hours of supervision. I actually kind of like it, leaving it a little bit more vague here, so people can either choose to do the percentage.
I think it's actually clearer as we've just written it here, period. Time and supervision can be counted toward the trainee's SPE. A maximum of 45 hours a week can be credited. 1 hour for every 9 hours. So I think it's clear. 1 hour for every 9 hours you worked, you can count that time and supervision does count toward total SPE, and you can, a maximum of 45 hours a week can be credited toward SPE, including the time and supervision. That's clear. Maybe we don't need to give an example. Is that clear to you?
She's stunned into silence.
I mean, if we say 1 every 8 hours, 8 hours being the workday.
Rolling back real quickly, are we saying the hour of supervision, is that inclusive of hours worked or in addition to? I think that's where we're...
Inclusive.
So if we're saying inclusive of, then it would...
It's included in the...
So of your 9 hours worked, one of those hours
No.
is
No.
supervision?
No, in addition to.
So how's that inclusive then?
Right.
So
But
not
it's
inclusive.
all inclusive when you're counting up your SPE total, but you are correct. You are correct. It's in addition to, but all of which can be counted
Right.
towards
Toward
SPE.
Including supervised professionals.
So I think the question is, how do we want to phrase it so that we're highlighting that it's included in your 45, but it's in addition to your hours worked? That's, I think, where we're getting our confusion.
Yeah, that's a good point.
So it seems like we're saying it's included in your 45 hours total work, but it's in
Right.
addition to your 9 hours worked.
Yeah.
If I can just ask a question, I thought you picked 9 because you wanted to end at 40, because you didn't like going to 45, but then you had 9 and then you went to 45, and so now I'm confused at why 9 is still used versus 10, and going back to the easy 10% ratio. There is, just for thought, food for thought.
So I think the thing is, what we want to say is including supervision, because all of this is SPE, how many hours a week do we want to count toward SPE? And that includes the supervision.
Back into the number.
Yeah, back into it, go that way. What is reasonable? I actually don't think it's reasonable that people work more than, I mean, I think 44 is a lot, but, you know. I mean, you know, you're talking by and large direct service. That's
So-
a lot of hours of direct service.
But it's up to, though, it's not, it's, the expectation isn't that they are, but it's that they can claim up to 45. So if you are if you are a particular person who works a set 40 hours, it's not mandating that you work to 45.
Right, that's correct.
So wouldn't that
So if we said
address
up
this
to,
issue?
yeah, thanks, I'm sorry, I'm just kind of talking as
No.
you're doing too. Yeah, you're right, so if we said a maximum 45 hours a week, including supervision, can be credited toward SPE. Do we want to say 45 or 44? That's probably the next question.
Well, the logic, I think, of the 44 was that it was 10% on top of the 40 hours.
Right. Right.
So we no longer have that situation. So there's a certain clarity to that. I don't think us setting it at 40 hours is going to prevent people in some settings getting overworked.
Oh, of course it won't.
So I would prefer to see those people get credit for as much time as I would feel comfortable them working. And I guess at the outer limits, 45 hours would be okay to me. I mean, I think everybody should work a maximum of 40 hours. I even think 36 hours is delivery of service is a lot of delivery of service for somebody that's relatively new in the field. I can't do that.
I mean, that's more than it's more than a full-time practice.
It is.
Yeah.
Yeah.
Question for the committee. If we took out the for example and we put in a table that had 0 to 9, 1 hour, 10 to 19, 2 hours, if we put in that table, would that be helpful instead of putting in the
Yeah.
The word
that might be good.
sentence?
Yeah.
Just seeing the numbers?
The only reason I question that is if we're saying it's a 9-to-1 ratio, and somebody sees 15 hours direct delivery of service, conceivably a supervisor could do 1 2/3 hours
Right.
of supervision
Right.
under that circumstance. I don't know if I got the math right, but you know what I'm saying. I'd like them to have the flexibility to be able to do that or to round up to the next hour, depending on what the institution, what the requirements of their practice and their time is. So I wouldn't mind giving them more flexibility in terms of how they're allocating that time as opposed to making some concrete step up. On the other hand, the advantage of the concrete step up would be people would know exactly what they're supposed to do.
Mm-hmm. And I think right now there's a lot of confusion.
A lot.
Yes. So I think providing them with a concrete step up, it sounds like most people do that anyway. And remember, only one of those hours needs to be the individual face-to-face. And if they're in an institution, individual with the primary supervisor.
Right.
If they're in an institution, they're going to have, group sessions. There are a lot of different ways to get supervision in those kinds of settings.
It might be scoring tests.
Exactly,
Yeah.
that are already blocked in. You know what I mean? It's
Right.
not like they're going to give 1 2/10 of an hour of supervision. I think that is most likely going to happen. That can happen in the flexibility of a private practice, but we're not giving credit for more than X number of hours. So I think that to say in this range, here's how much you gotta do. I'd rather have more supervision required, even for less hours. I think that can't hurt versus, people getting shortchanged, the supervisees getting shortchanged. So, I just think that will help more people.
We'd have to look at the chart now we do
Yeah.
it, because where the breakoffs would be significant. I think it's 0 to 9.0.
Mm-hmm.
It's 1 hour. 9.0 plus up to 18 hours would be 2 hours.
Right.
Or 8 to 18.0,
Right.
and then 18.0 plus, or 18 plus
Right.
through to,
Right.
so we'd have to.
We'll take a look at that, because divisible by 9, basically. So.
It would be the most straightforward. It might create the least confusion. But Stephanie, you still look famished.
So if you would, are you okay? Like maybe to create a.
I can try to put one in.
Okay. Because we're going to want to bring this back and take a look at it. So take out the for example part.
Yeah. I'm just going to put it below this.
Are you doing it now?
2 columns. Natasha, come on over, you love tape.
I do love taking.
Yeah. Is the 9, is that Up to 45?
Up to 45.
Up to 45, okay.
I
Okay,
think-
so 5 different, okay.
I think part of the
So it
confusion.
would be 5 hours of supervision,
Yeah.
because can't be a half.
So, are you going to 45? That's fine, okay.
I think part of the confusion might be because to get to our 45, we're doing essentially 9 times 5.
Oh, yeah.
And so that presumes that that person's working a 9-hour day, and of that 9 hours per day that they've worked, one of those hours was supervision.
No, because that'd be a different percentage, but it would assume for each 9 hours they work, they would get an additional hour of supervision.
So that means they're working
So
10
that's
hours a
10
day.
hours.
Well, then you go to 50 hours as being the maximum, right?
Right.
So maybe we want to,
So I think part of it is while on the one hand, we want to let folks who are working more than 40 hours a week to claim that time, I think there is a message potentially that's being sent that, well, if you can claim up to this hours, then there's a blessing,
If we did it this way, 0 to 10, and we'll think of the wording later, 0 to 10, one of those hours is supervision.
right?
So that's inclusive in there.
Okay, that makes sense.
Okay. 11 to 20 has to have,
It'd be easier to read the chart, that's for sure.
Yes.
so I think that's, yeah. So 31 to 40,
Would have to be 4 hours of supervision.
yeah. And so that caps it at 40 right there.
You know, as I think about this and as I listen to what you said, Mr. Phil, I don't know we want to sign off on more than 40 hours a week.
There you go. Here we go again.
I
Exactly.
mean, aren't we in a way giving our imprimatur to people having to work excessively long hours in a setting where and while they're in the middle of training, doing incredibly difficult things?
But if we're allowing the
Total count CE would be 40.
44, so what happens?
So
So
you're
you've
back to
made
the
it
0 to
over and above.
So you're going back to the 0 to 9 with 1 additional, making it 10 total?
No. 0 to 10 hours worked means that one of those 10 hours has to be supervision.
One of the 10 hours would be supervision.
Oh,
And we have to make it clear it's included in the 10 hours.
Yes.
got it.
And I think we cap it at 40 then, and then we get out of the confusion of all these
Yeah.
odd numbers and
Yeah.
examples. I just want to ask the licensing staff, how are you feeling as you hear this? Shout out to licensing, does this feel comfortable?
I think with this is definitely more clear than now, because right now it's we're doing the additional 10%, so like the 40 plus 4 hours. So if this is gonna be the framework for us, I think it would work.
I like full numbers.
Yes.
Okay. So, yeah.
So,
Yeah, they're all supervised, but, yeah, how many hours supervision must be included in that amount, or something like that?
So it would be of hours worked, supervision hours, and then 1, 2, 3. Because I think that's what we're trying to capture to keep it within
Right.
that 40.
Within those hours worked.
of hours worked supervision?
Minimum hours of supervision,
Yes.
maybe a little too
No.
low.
We want it, but we want the, we want the supervision within those hours, so
Supervision credited?
supervision, yeah, it's something like that, you know.
Of course.
How many hours of supervision within,
Of the hours work supervision required,
Required.
something along
yeah,
that
or
flavor.
within that 0 to 10,
Mhm.
how many hours must be,
So even if you worked 5 hours,
yeah,
one of the 5 hours has to be in
If you work
supervision.
1 hour, you get an hour.
yeah.
Right. Or if you work 1 hour, 1 hour has to be supervision.
Right,
Right.
So you can't kind of just.
right.
Should it be
Right.
direct supervision?
Oh, so it would have to be 2 hours.
Required?
Or that 1 hour would have to be a supervision hour.
Yeah, this is with the primary
Which is unusual.
supervisor, right?
Yeah.
So yes,
Yeah.
Should be direct,
direct supervision.
because all the hours are supervised, like you were saying this, Mark.
It should say, they're all direct, right? and 3 hours could be individual or group supervision. In the example you gave. I would just say supervision, and then maybe we can say, 1 hour a week must be with the
Primary supervisor.
primary supervisor.
That's, I think
We can
that's
just say
already
that
in
separately.
We already say that, don't we?
Oh, there we go.
Yeah.
That makes, yes, time spent in yes.
Yeah, perfect.
That.
Thank you, Mr. Patrick.
Takes a village.
So now we're back to the 40 and then.
Now we're back to a maximum of 40, and that includes the supervision hours. And we want to say,
Real quick, it might be time spent supervising, because in supervision suggests you're being supervised rather
That
than
is
supervised.
being super.
Okay,
This is.
Yeah.
just want to make sure.
yeah. And,
I think we take the example out.
Yeah,
yeah, take the
example's coming
example
yeah.
out, but I do think we want to say in there, 1 hour, yeah, at least 1 hour per week must be in direct individual supervisor with the primary supervisor, period. So that means if it's just 1 hour, that one has to be. If it's 2 hours,
But don't we say that somewhere else?
we've said it, I'm just saying
example,
leave
but I
it
don't know.
in, because we're changing,
Oh, yeah.
yeah, just leave it in.
We don't need to
But
put
I
it
think
again.
that
We don't need to repeat it
clarifies
again here.
Huh?
We don't need to repeat it again here.
This is the only place we say.
Oh, is
that.
it the only place
Yeah,
we say it?
I'm
Okay.
where
trying
we
to
have
take the
it.
example out and not remove that portion
Oh,
of it.
okay, I got you.
But I don't know how to do that. For example, which two
Maybe I had too much caffeine.
Take out the whole, for example, and then let's maybe build from,
Do you want me just to take out up to here, and then we can start with the new opening language?
yeah,
Yeah.
yeah.
Scroll up a tiny bit so we can see what the
The new
header,
language?
the new language is.
I'm gonna work on integrating.
Because that's all new language.
I would take out the supervisors, I'd say of the total hours worked, supervisors,
Where are you?
oh, no, because we have it singular or plural, never mind. Must supervise the trainee 1 hour, let's see.
Why don't we just say 1 hour of which must be direct individual
Right.
supervision with their primary supervisor and end it there?
Take out the rest.
Yeah,
Yes,
because
exactly.
let him figure out, or you can, instead, do you want to say and the remainder
No,
with, just remove it, let him.
yeah, remove it.
Perfect,
That's the only one we're putting any
way too.
limits on. Yeah, 1 hour a week has to be with the individual supervisor. But now we're not for an additional 10%, so we don't have that there anymore.
I have
Um,
a question, sorry.
Yeah, I'm reconciling as I read kind of right now. So don't mind me.
I have a question on line 24. Did we already say that the 1 hour per week must be in direct supervision? Is it repetitive of the last sentence on line 29?
Yeah, you're right.
You're right.
I would take it out, this earlier place, and leave it where we had it.
Or read it as if that's gone. So it'd be of the total hours worked, the supervisor must supervise the trainee 1 hour for every, 10 hour, worked each week. Time spent in supervision can be counted towards the trainee's SPE. A maximum of 40 hours can be credited towards SPE. And then 1 hour per week must be in direct individual supervision with the primary supervisor, period. That's how it would end. And then we'd go to the chart.
I think you need that sentence about the additional supervision can be provided by the primary delegated or co-supervisor.
Just that one,
Okay.
yeah.
Perfect. I'll just cut it for now and have it available.
Yeah, good. Now, you gotta mix these
Yeah.
two,
That's
and we
good.
don't have 45 hours a week.
No.
We just took out some of the language.
I don't think so.
'Cause can you put it back?
Yeah, I have it. Yeah.
We don't want to take out the sentence, time spent in supervision.
No, we want to have it somewhere else though. I mean, we want to have it, see, up number 4 up at the top and number 4 at the bottom, they're not accurate. Neither one are accurate. If we,
Oh, I see what you're saying.
we have to,
Yeah, let me integrate the language right now.
Yes.
yes.
Yeah.
If we could do a mock-up of an unmarked copy, I think that's what we're looking for, right?
Did I seem like I needed Other timelines work. Supervisors must supervise trainee for 1
Hour.
Take out the 4. 1 hour for every 1 hour. Of every 10 hours worked.
Up to.
A week.
Yeah.
1 hour for every 10 hours, right?
Up-
10 hours.
For up to, but it's within that 10 hours. We're saying the supervision counts in that 10 hours. Maybe we could just say see chart below.
This is as good as we got. See below.
Here, this is what we're doing.
I think for every 9 hours will work, because just looking at the chart, so for example, they work 27 hours, so then they fall into the third row of the table, then, then they need 3 hours.
That's true.
So I think that works,
Yeah.
if we keep the verbiage for 1 hour for every 9 hours.
But we're not doing a maximum of 45 hours a week.
Yeah, I gotta remove that.
Stephen, this is for you. No, take one. I don't need this.
And then,
Look what you left. Oh, you don't like that?
You got confused. I don't like them either. Okay, so we're at this bottom 4. The total hours worked, supervisors must supervise the trainee 1 hour for every 9 hours worked each week.
But we're not, I think the difficulty I have with the 1 hour for every 9 hours worked is you can work less than 9 hours, but you still have to have 1 hour
That's correct.
of supervision. And so I think to express the language, it may need to express the range that we've listed. So 1 hour for hours worked in the ranges below.
Yeah, I
Is
wonder
that
if we can
possible?
say, time spent, I wonder if we can start it this way. Time spent in supervision can be counted toward the trainee's SPE. A maximum of 40 hours per week can be credited toward SPE. 1 hour per week of supervision per week must be in direct individual supervision with the primary supervisor. The additional supervision can be provided by the primary, blah, 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 blah. And then say, for the range of hours and supervision required, see chart below. So that we're not putting the number of hours in our explanation, but we're,
Part of the problem is we're trying to do like a 6th grade math grade word problem.
right.
It's,
I always had trouble with work.
clearly we all did.
you ready to repeat that whole thing you just said?
Okay, so what I did was I just took everything out that referred to numbers. So we started it with time spent in supervision.
Okay.
No, that's right, that's right.
Yeah, well, if it's in there already, I'm just gonna use the existing language.
Time spent in supervision can be counted toward the trainee's SPE, and
Okay.
that's apostrophe S.
Oh, trainees. Oh, got it.
Or trainees apostrophe. I would say singular. Time spent in supervision can be counted toward the trainees SPE. 1 hour,
So get rid of a maximum of?
right.
Doesn't it possibly be
The what? It is before, oh, no, he changed it. It's
Thought you wanted
trainee
trainees.
apostrophe S.
I had that.
It's singular, that's what I thought. That's what was going on. 1 hour per week, 1 hour of supervision per week, I'll say, must be in direct individual supervision. Oh, no, we could say 1 hour per week must be in direct individual supervision with the primary supervisor. Additional supervision can be provided by primary delegated or co-supervisors. Time spent in supervision can be counted toward the trainee's SPE. A maximum of 45 hours per week can be credited. 40 hours per week can be credited toward.
Please don't change.
So is that going to be, workable for the, I think there were some of the training
I know. So we're probably going to have somebody comment on that right now.
Do you like it ending with credited?
Say that again?
Do you like it ending with credited, period? Or am I missing a word at the end there?
40 hours per week can be credited toward SPE.
Mr. Glass-Spiegel, on your last sentence, starting on line 22, the M for maximum just needs to be uncapitalized.
Thank you.
Okay, so now if we read number 4, it says, time spent in supervision can be counted toward the trainee's SPE. 1 hour per week shall be face-to-face.
Must be indirect individual supervision with the primary
Yeah.
supervisor, period.
Sorry.
No, you're fine. Go and keep reading. Additional supervision.
Additional supervision. Take out this time spent in supervision because we already have that as our first sentence. And then say a maximum of 40 hours per week can be credited toward SPE. So, and how does this section start? What is?
It's way back.
Of the total. Okay, so that's fine, that's fine. I just wanted to make sure we weren't using a different way of starting this thing. So how does that sing? Time spent in supervision can be counted toward the trainee's SPE. Do we want to say that first? Or do we want to start with a maximum of 40 hours per week can be credited toward SPE? Time spent in supervision can be counted toward the trainee's SPE, at least 1 hour. So change that last sentence to first, if you will. And then I think we're okay. And then we want to say something about, see the chart below or something. So can we say see below for, or what do we say? Can we say see below for? SPE requirements. See table below, yeah. For supervision requirements, yeah.
That's an editorial comment.
No, for supervision requirements. Isn't it supervision requirements?
Yeah. Supervision.
Yeah. This is, well, the section is supervised professional experience, but yeah. This is just the supervision requirements, yeah. All right, we think we got it? How does that look to y'all?
So we want 45 minutes.
Now, we are going to open this to public comments.
We did avoid the word problem, though.
I'm sorry?
We did avoid the word problem.
This is Marilyn Imos from CDCR. I can say right now that this is very satisfactory, this result for CDCR. We really do have a 40-hour week, and particularly with unlicensed clinicians, it's very well regulated, and people watch out for that. If you change anything in the body of the text or a table to something that isn't in the metric system, you're going to get so much confusion, and I'm going to get a lot of telephone calls. So I really appreciate this, also from a personal standpoint, that it's clear, and even the 10%, so I would just say, look, CDCR has a minimum of 2 hours of individual supervision, whereby at least one needs to be with the primary supervisor, and 2 hours of group supervision. So we had that actually, it's not policy, but it's unwritten, what we tell people. So exactly, they're not allowed to work more than 40 hours a week, so this is what it is. If you move that 0 away and put anything behind that 4, we're going to have a lot of problems. So this is really a good solution. And the other thing I was thinking of, I think the table is a great idea. I could imagine that nobody is going to read the text. They're going to zero straight to the table. They don't have much time. The supervisors are going to say, oh, that's clear now. Now I don't have to do any math.
Great.
So thank you very much in the name of CDCR. I think this is a really good solution.
Thank you. All right, can we move on? Do we need a break? 5 minutes? We're going to take a 5-minute break. Back in session, and before we move on, I think Ms. Marks had something she wanted to ask us about.
I think my one question would be with deleting face-to-face, whether or not the board, and this is a policy issue for the committee and ultimately the board, is whether or not that changes the quality of the supervision. I know, I think there was a reason why it was face-to-face. I know technology allows us to communicate in many other ways. I also know that personally, my communication when I'm on the phone at home is probably not to the same level of attention as it is if I'm looking at someone. And could the board consider increasing the chances of using technology, but still maintaining that face-to-face requirement with FaceTime or Skype or something where you're still being able to make contact and people aren't multitasking while they're on the phone. And that's only because I know that I have a tendency to do that. So it's just a suggestion to potentially have a small baby step toward increasing the use of technology rather than wholesale saying, go ahead and just communicate in any way you find possible.
So what you're saying is that we would change our definition of face-to-face if we included technology, but that was visual. It would have to be HIPAA compliant and it would be visual. But that would be face-to-face. So the chance of maybe being inattentive or not
Correct. Or
adequately reading this trainee or something like that, which when you're just hearing someone's voice or something like that, it may be. So what do y'all think about that? It would change the definition of face-to-face.
I actually don't have, I think most of us take our supervision very seriously. So I can't imagine myself like wearing board shorts and. Oh, sorry. I can't imagine myself, given the nature of the relationship, not taking it seriously, even if I did it by phone. And certainly I think all of us that have supervised before have had times when the only way of communicating with someone, let's say they had a clinical emergency come up, was by telephone. I felt comfortable I was giving good supervision, I think under those circumstances.
Just keeping it at direct.
Direct as opposed to direct visual. But I certainly understand what you're saying, Ms. Marks. I mean, ultimately, so many of these things are dependent on how seriously the psychologist takes their responsibilities. And I think the vast majority of us take them very seriously. And then there's going to be people that don't. And even if they had the visual information, they might not be paying attention.
Like falling somewhere in the middle of this, where I think there is a visual cues can be helpful in terms of this SPE requirement. I think at the times when in those emergency situations, I don't think we're looking towards those emergency situations to count towards SPE. And so
No, I was just using this.
okay, that's helpful. But I think recognizing the balance, the balance you struck earlier about how technology is advancing and how we can accommodate that technology, but at the same time recognize that there is the visual components that are important to it. So thinking about how we would think about face-to-face.
So my initial reaction was essentially the same as yours, and which is one reason I asked Ms. Marks to bring it up for us to think about. And because as I heard her talk about it, and even as I heard you talk about it, Mr. Fu, I do think this is kind of a place in the middle. It allows, you can even do FaceTime's not HIPAA compliant, but if we said that the technology has to be HIPAA compliant, even with direct supervision, I think we might take care of some of the concerns. I don't know, I'm just trying to think about it. They wouldn't necessarily be visual. One of the things I was thinking is, I do think by far the majority of people, I might be wrong about this, so I'm looking to Ms. Chung about this, but I think by far, she didn't hear me, the majority of people who become psych assistants once as a postdoc. I think that's probably what we're more likely to find. I'm not sure. I'm asking that question.
In other words, are the majority of people that we'd be concerned about whether they were getting direct face-to-face supervision, would that be primarily in the context of psychological assistance, since otherwise if you're in an institutional or training setting, typically your supervisor's either on site or they come to the site to get
But
the
all psych assistants aren't it's not postdoc supervision. So where do those psych assistants fall on the continuum? Are they pre-doc, postdoc?
For the psych assistant, just to clarify, for the psych assistant that is asking, or their supervisor is asking whether they have to do it through secure conferencing, video conferencing?
No, I'm just asking of our psych assistants, how many of them are working on postdoc hours versus how many are working on their pre-doctoral hours?
I can't give you that stat top of my head, but that's something that we could research and give you more solid answer the next time we meet, or I can provide those statistics to you through email.
If we have it the next time, and we don't have to do this right now, but if we had those, because one of the things I'm thinking, if they are primarily postdoctoral hours, I don't think face-to-face is nearly as important. They've had all those pre-doc face-to-face, in the same room hours, and at this point in time, they've had all their practicum experience and typically their internship or whatever. And so this is later in their much later in their training after years. So that wouldn't be that important or seem as important. So I would actually find that helpful if you would bring that number, and then we'll see.
I suspect that it's majority postdoc.
That's what I would think, but
We don't know.
we don't know. Thanks, Ms. Martz. That's good, and it really does give us something to think about. Where is
And I'm just thinking this may be a discussion that would be good, no matter how we present this package to the board, to highlight that as a
Right.
particular issue for the board as a whole to discuss.
That's not bad. I think we're going to want a recommendation.
Right,
But
and I think if
to
we have
make a
more statistics, we'll.
Yeah. Okay. So this will come back at our next board meeting, this particular part. All right. So now, where are we in our part B? Is that it?
That's it.
Are we done? At 2:30?
Exciting.
All right, so let me see. Then I think we're going to go into a closed session at this point in time. I don't see any public members in the live audience here. And so I want to thank anybody who might be watching in on our webcast. But we're going to go into closed session right now, so we'll only be coming back to adjourn the meeting. So for all practical purposes, I would say this is the end of the open session. Thanks everybody for watching, and we'll go into closed session now.